Hello. Lordship's kind permission, may I be permitted to mention a matter? This is a writ petition pertaining to rejection of a nomination of a candidate for the ongoing municipal elections in Mumbai. Because of one missing signature, we had moved the matters, all the verifications and the objections are removed. It was supposed to be listed yesterday. It has not come on board. It was supposed to be listed today. As per the case status of the Supreme Court website, it has not come on board today. Tomorrow is a holiday, Lordships. I'm pressing for production today because the matter will become infructuous because the elections are day after tomorrow, Lordships. Just one missing signature, Lordships.
Let it become infructuous, we don't mind. But I will not list on the same day. Thank you.
Lordships, may we have it on the 15th then?
Election petition करेंगे ना. You're not something that. Look.
My lords, may I make a mention, my lords? My lords, I'm mentioning a writ petition. This is regarding SIR in West Bengal. My lords, a counter had come and they have confirmed the instances of violence, my lords, 6 instances. Because of the ongoing violence, my lords, we are requesting that today, my lords, at 2 p.m. are taking the Bihar matter, my lords. My lords, let this writ petition be also taken up along with it, my lords. May I only...
West Bengal matter, yes. Yesterday it was argued by Mr. Sibbal. I had issued notice in, so we have issued notice in matter.
Okay, my lords.
And given till Friday time to them to file the reply, matter is coming on Monday.
My lords, may I then give my writ petition number? That may also...
Unless you have now hundreds of spread.
No, my lords, I am actually led by Mr. Giri. He's on his legs. But I'm
Everywhere
only making that request on his behalf that at 2 p.m. this matter may also...
Advisably, all matters of West Bengal now can be taken on Monday.
Please, my lords.
Where the notice has been issued, they have been asked to file the reply. Matter is likely to be taken up.
Please, my lords.
So you give your numbers, we can list those matters also.
I'll give the number, my lords. Deeply obliged.
It is like this order of adjudication from the
Item one, who is appearing there, this.
Wait, please, my lords, I appear for the respondent, my lords.
You are the respondent, but this order has already been upheld in your favor.
Yes, my lord. 2 orders of this court are there where they have dismissed the SLPs.
So for the reason, who is appearing for the revenue, please mark his presence, whosoever comes. In view of the fact that SLP civil number 31681 stroke 2024 arising out of the influence judgment has already been dismissed by this court by order dated 3rd November 2025. We see no reason to take a different view. The instant specially petition is accordingly dismissed.
Obliged, my lords.
Lordship, I am Balasundaram Balamurugan. I am party in person. This is the public interest litigation regarding removal of.
Where are you, Mr. Balasundaram?
Lordship, I am in Chennai, Lordship.
You are in Chennai. We thought you will come to Delhi.
Yes, Lordship. Due to some financial issue, I could not make it, Lordship.
But
Can I continue, Lordship?
yes, you can always continue.
Yes, Lordship. Lordship, I've filed an IA for to appear to permission for appear in party in person and argue. That may be allowed, Lordship.
When did you retire from Indian Revenue Service? To Delhi, you come in, argue and show your service record. We would like to impose to Delhi. You come in, argue and show your service record. We would like to impose exemplary cost on you. What do you think yourself?
Lordship, this is for public interest, Lordship. I am not. I don't think anything wrong in it. Lordship.
First deposit a sum of rupees 1 lakh in the registry so that we can impose cost on you. Then we will tell you what is the meaning of public interest.
Yes, Lordship.
Keep on wasting time of the courts.
No, Lordship. I'm sorry, Lordship.
What do you want now? You want to impose the cost or you want to withdraw it silently?
Well, I'll withdraw it, Lordship.
Better you withdraw. Please don't indulge in the. Enjoy your retirement now. Have some constructive role in society.
Yes, Lordship.
If petitioner in person who has appeared online seeks and permitted to withdraw this petition, this will be withdrawn.
Lords, the impugned order in this case, Lord, suffers from the gravest form of infirmity.
Strong inclusion.
Lords, in the order, it suffers from the gravest form of infirmity, my lords. The very rules which forms the basis of my service, seniority and confirmation, my lords, that do not apply to me. My lords, it's a limited scope under which the Honorable High Court has seen up till the Rule 18. But my lords, Rule 20,
Hon'ble on short.
Lords, I'm requesting for an interim stay. Lords, there's a
Lord,
reason for
can't
that.
we-
Lords, there's a reason for that. The state has sent that for year 2020, 21 and 22 UPS.
Pass any interim order.
Lords, then there is a criminal MA, I'm sorry, there's a MA, Lords, inducting UPSC as a party. Lords, may kindly direct
That
that.
we can allow.
And Lords, that for the subject of outcome of this, Lords, the promotions in the IPS may not be considered till this honorable court.
So promotion will take place. Why should employee tomorrow? If you succeed, you will also get from the back date.
Lords, my difficulty is that then I will become infructuous.
Be allowed. UPSC is also made party respondent number so and so. Let notice be issued to so and so to the respondents.
My lord, we are here.
Whosoever is
I'll
appearing-
reply on behalf of the state, my lord. My lord, it can be taken.
Whosoever is appearing, you give your memo to accept notice on behalf of so and so respondents. The counter affidavit can be
division
filed
bench,
4
Lord.
weeks. The appointment to Indian Police Service, if any, shall be subject to outcome of this procedure.
So grateful.
Very well.
Seems that my writ petition has been lost, my lord, among the other bunch of petitions. My lord. I
You have
challenged-
already
I have not
discussed
challenged the
How many
notification.
times you will?
Lord, I have not challenged the notification. My grievance is the notification itself has not been
Thank you,
followed, my
thank you
lord.
very much, thank
The
you.
notification says, my lord, the inclusion shall be within 6
We
kilometers.
have heard learned counsel for the petitioner as well as Mr. Nataraj, learned additional citizen of India on behalf of the state of Rajasthan. In view of the fact that similar matter bearing SLP civil number 34 of 2026 arising out of the same influence judgment has already been dismissed.
Lord, my case
Now
is,
we see no reason to trigger the
my case is different from those cases. Those two cases which have been dismissed, my case is different, my lord. My case is completely on the factual aspect, my lord. The notification which has been issued by the government has not been followed, my lord. It clearly says that my lord, these are two villages, my lord, adjacent to each other, 350 meters only, my lord. Now, with the inclusion of my village in the new Gram Panchayat, my lord, the distance would be more than
Let us,
10
let us
kilometers.
leave something to be done by the government also. Everything the court will start doing.
My petition actually has not been decided by the Honorable High Court.
You can pursue whatever. Then you don't,
May I
it's
be
not a.
permitted to go back to High Court, madam, because
No, no,
my,
no,
my
no, first
petition.
of going back, we can't allow you to go back anywhere.
My-
If you are matter, if you have case pending in the High Court, then probably it's wrong advice that you should not have filed the SLP.
Lord, my petition has been decided, but Lord, my aspect have not been considered.
No, no,
Lord.
nothing can be done now.
Lord, I may be
It's a
permitted.
well-reasoned judgment, very,
Lord, it is
very well.
I'm not challenging the part which has been decided by the High Court. It has rightly been decided by the High Court, my lord. Even that High Court judgment, my lord, has not been applied in my case.
Thank you very much.
Please, ma'am.
Applied.
Madam, in this case, madam, while this honorable court is monitoring the implementation of the fixation of for older vehicle, the High Court completely turns the table, madam, and says it is all optional. All, madam, there are 26 states and UTs in this country, madam, which are
This
implementing.
kind of so-called PILs are normally sponsored by the manufacturer.
PI, madam, this is not a PIL, madam. This was not a PAL, my lord. I am the HSRP manufacturer, my lord. All we wanted is state came out with a tender in 2021. But that was upheld by the High Court, by the same Tamil Nadu High Court. Then the government recalls that and then does not even want to, my lord, implement the scheme. This honorable court, my lord, seeks the compliance report. They don't
These
file
are
the
not the matters we should enforce through PIL. These are all policy decisions. But the government will
But
take
this is not a
it.
policy. Kindly have the impugned order, my lord. Para 2.
We have seen that.
Well, then para 5, my lord. It makes it the entire scheme optional, my lord. The rule says it shall, my lord. The word
It is optional scheme.
but it is
Scheme
shall.
itself is optional. It, after all, it has financial consequences, not only on everyone.
May kindly then have this order passed by this honorable court, which is at my lord, annexure P17, my lord. Have page 160 of this. This is an MC Mehta case, my lord. Well, I'm relying on a PIL, my lord, but mine was not a PL. I only wanted the implementation of the scheme. I am a HSRP manufacturer.
No question. No dismissal.
Lordships has already seized with the matter. Rahul Ramesh Wagh. This is pertaining to the municipal elections in the municipal corporations of the Maharashtra Lordships. Lordships has fixed this matter for 21st of January 26.
Regional litigation we will continue to face till this election is not held.
No, Your Lordships, the difficulty here is that notification is issued on 8th of October 2025, wherein that specific seat was reserved for the scheduled caste. Thereafter, when it was notified, it was reserved for a general woman.
The constitution, at least our constitution professes inclusivity. So what is wrong if the post is reserved for scheduled caste?
As per your Lordship's direction, in order dated 6th of May, Lordship has passed accordingly that 1st October notification has been issued and seats were reserved as per minimum 27% criteria. And accordingly, 8th of October, that another notification come where that specific seat is reserved for the scheduled caste. Now, after 4 days, it has been changed without any approval, without any reason, RAM, your Lordship. And thereafter, I have made a representation which has not been decided yet. My only submission is this petition may be tagged with my representation.
No, nothing is to be tagged. We'll consider in that.
At least my representation may be decided why this has been happened, your lordship, despite of your lordship's direction for the 27% reservation.
You want to withdraw and whatever at the time when the matter is finally heard, you want to raise issues at that time or we dismiss it?
Then your lordships may tag it with that.
No question of tagging. With this tagging is also a very difficult problem here. You don't allow the main case to be completed. Tagging.
This per se, there is a illegality, your lordship. Their own notification saying, and after 4 days, they are simply just changing that notification, their own things. My representation at least may be decided on that aspect, your lordship. My representation.
Petitioner is said to have submitted a representation to the divisional commissioner. Which place?
Pune, Dawn, it's a Dawn district, Pune, your lordship.
Divisional commissioner Pune.
It's a Patas village, Dawn district.
A reservation of the seats for question of the day reservation of seats.
That
OBC, no?
नहीं ओबीसी नहीं एससी था फिर जनरल एससी का था जनरल वुमन कर दो with one person.
Let the instant reputation disposed of with liberty to the petitioner to pursue application.
obliged.
With due respect, the High Court has heard both on fact and law, my lords. I moved an application under section 11(6), my lord. The High Court holds that the limitation will be counted from the date of completion certificate, whereas admittedly, my lords, the bills were settled on, my lords, I have mentioned the date, which has not been taken into consideration. It was 9/1/2020, my lords.
Please see, my lords, page 92. The bills were settled on 9/1. Yes, my lords, may I continue?
Yes.
My lords, page 92, my lords may say, the bills were settled and there was correspondence, internal correspondence with the department. I filed that
Yes,
also.
will continue.
My lords, please see 92, my lord, the bills were settled. Completion certificate. After that, they had been writing to settle the bills. They did
Some of
not
the-
settle the bills.
Some of the judgments of this court are completely misconstrued,
Minutes.
as if nothing is left for the courts to examine. Courts are only postmaster to refer the.
My lords,
That
there
is
is,
to the
I'll
arbitration.
come on law, my lords. I'll refer to three judgment. Just allow me 1 minute. My lords, page 92 may be seen, my lord. The cause of action actually arose on 9th of January 2020. My lords may just see that document.
All kind of things, and ultimately after taking money, the government are becoming all for these contractors with the minting machines.
My lords, that's not the case in this case, at least, my lords. Here is a case, my lord. Please come to page 92, my lords. Admittedly, my lords, the bills were settled on 2020, my lords, and within 15 days, I issued a notice invoking arbitration.
When was your notice for
Notice issued,
arbitration? Sir?
Yes, my lords. The bills were settled on
When was your notice for arbitration?
notice for arbitration, my lords, is issued on 24th of January 2020,
When-
and bills were settled on.
When did you file your application for reference?
Yes, my lords. The application was filed on 20th January, 20th November 2023.
It's barred by limitations.
No, it is, it will exclude the
Barred
COVID
by
period, my lords. It
limitation.
will exclude the COVID period. COVID limitation is excluded. I have filed the order also, my lords, that 135 days something is excluded. There is a judicial order of this court. So if we exclude that, and then, my lords, during that period, assuming, my lords, that I gave a notice on 9th January, COVID period is excluded. BSNL issued me 2 documents calling me upon to reconcile and mediate and settle the matter. There are letters I have filed on record. So, my lords, this was a discussions and negotiations were ongoing, my lord. There are letters on record.
12 issues settled.
My lords, the High Court has said is, with due respect, my lord, the High Court has said, my lords may not just go by the High Court order. It is factually incorrect. My lords may just see one document, page 92. The bills were settled in January. I have mentioned that at the High Court, I file a review. I seek for correction of error apparent on record on facts. The High Court doesn't correct it. My lords, the High Court order, if it records incorrectly on facts, what will I do, my lord? The only remedy is before this court.
So the only remedy was to come to the court promptly on time.
My lords, I could, my lords, please appreciate, when would I have agitated the issue as per section 25 only, when the bills were settled. Till 2020, my lord, the bills were not settled. Page 92 may be seen, my lords, for a minute. That is not taken on into consideration by the High Court.
If the bills are not settled for 50 years, will it amount to giving limitation?
My lords,
Give me.
my lords, Krish is spinning, and
You
my
are
lords,
very
with due
prompt
respect,
taking action.
now I'll come to the law, my lords. With due respect, my lords, if my lords are of that opinion, my lords will have to reconsider the 3 judgments of Krish spinning. May I pass on? My lords have taken a view, 3 judgments, my lords. Krish spinning, my lords have taken a view that 11(6) limitation for filing will commence on the day when the notice is issued. The limitation triggers the day the notice is issued. So in the case, the bills were settled, my lords, admittedly on 9 January. Within 15 days, I issue a notice of limitation as per Krish spinning. My lords, may I just refer to those paras? Allow me, my lords. Allow me. I am open to assist the court to reconsider that view. Erroneous or not, my lords, it is binding. Pass on. I'll read from 131. This all is happening, my lords. This all is happening, my lords, because of an error of fact in the High Court order. I have said that. My lords may just come to para. I pass on the judgment copy. My lords, para 131. Krish spinning. I'll read 4 or 5 paras. Allow me. My lords, today, if my application is dismissed, I'll be completely remediless. Why? Because I cannot resort to arbitration. I cannot.
You don't have any grievance. It's only out of greed that you are raising some afterthought claim.
That's not the fact here, my lords. That even
if it is settled, payment received,
With due
If you
respect, my
want
lords,
to reopen anything, these
even-
are all blackmailing
Let me just
activities,
see the
mostly
judgment.
in collusion and connivance with officials
My
of these
lords
government
may-
entities.
My lords may not have that presumption in that case. In this case, my lords, this is a glaring case, my lords, where the bills were not settled for 9 years. Their own officers were writing, I have filed the
That
complaint.
was, if the bills were not settled 9 years, that was the time that you should have come to the court immediately.
My lords may just see this judgment, my lord, Krish is spinning. Some paras I want to show. And this has considered the long line of precedents when the limitation will start accounting from under section 11. So my lords will have to revisit this view with due respect. Para 131, page 61 of SCC. SBI General Insurance versus Krish Spinning. I'll just read 4-5 paras, my lord, just to give a holistic picture of the law which prevails today.
Yes, yes.
That is before, my lords. Para 131. I'll rather start from, my lords, para 129, where the issues are framed. That is before me. Para 129, 61 of SCC, 61. That is before, my lords.
Yes, we have seen.
Before we close the matter, it is necessary for us to clarify the dictum as laid down in Arif Azim Company versus Aptec so as to streamline the position of law and prevent the possibility of conflict between the two decisions. The two decisions that may arise in future. In Arif Azim, while deciding an application for appointment of arbitrator under 11.6, two issues are arisen for our consideration. Whether the Limitation Act is applicable to an application for appointment of arbitrator under section 11.6. If yes, whether the petition was barred by limitation. Whether the second issue, whether the court may decline to make a reference under section 11 where the claims are ex facie and hopelessly time barred. Then 131. On the first issue, it was observed by us that the Limitation Act 1963 is applicable to the applications filed under 11.6. Further, we also held
dispute regarding limitation in this case.
Yes.
The only defense plea was
Just-
that the
just-
claim had already been satisfied.
Just few more lines.
Therefore, there was no question. That's why the court says the preliminary issue will be whether the accounts have been settled
Yes.
and satisfactory.
Just few more lines allow me to read, my lords. I'm coming to those lines. Duty of the referral court to examine the application under 11.6 is not by period of limitation under 137. That is 3 years from the date when the right to apply accrues in favor. To determine as to when the right to apply would accrue, we had observed in para 57 of the said decision. Please see, it says, my lords, then they have quoted para 57 of Arif Azim. Allow me to read that, my lords, and then it is affirmed by the three judgments. It says, the limitation period for filing a petition under 11.6 of the 1996 Act can only commence once a valid notice invoking arbitration has been sent by the applicant to the other party and there has been a failure on refusal of that part. ये बंद हो गया यार।
Clerical mistake or whatever mistake you committed in submitting a bill, at page 107 P7, they pointed out to you that mistake is there, and if you rectify it, and if you submit the verification of all the, after checking the bills, then they were willing to pay whatever balance amount was also there. It's not a dispute.
107, my lord.
They were willing to
That's-
pay.
Yes, ma'am. That's in 2022.
23, not a 22 rather.
110.
But that is not a dispute. Had it
Yes.
been a case where they are disputing your amount, they are only pointing out your mistake, that in one of the bill, you have committed this mistake. They tell you that you rectify this mistake, submit a corrected bill and take that payment also. So where is the dispute?
Yes, my lord. That takes me to my another contention, section 18 of Limitation Act.
He wants to, under this garb, he wants to reopen everything.
No, my lords, I do not want to reopen. My lords may just see section 18 of the Limitation Act. Section 18 says where there is an acknowledgement of debt, my lord, then limitation period shall continue to run, my
There
lord.
is no acknowledgement of
Yes.
debt. There is no acknowledgement of debt. Acknowledgement is that because of your mistake, there appears to be dispute about there appears to be some claim by you. They say, please produce the corrected bill and take the payment if there is any.
Just see one more letter at additional document A3, page 14, where they themselves said, my lords, that settlement of pending bills. Please just see additional documents, page 14, A3. This is of 2024. That's why I'm saying, my lords, it is ongoing and continuing
Some
process.
official, you cash over there, you.
Lords, with due respect, not everything can be presumed against me, my lord. The department may also be at fault.
Yes, yes.
Yes, ma'am. Page 14, A3.
Page?
14, A3 of the additional document application, my lords. That must be on record. We filed on Saturday. Office. Copy is being given, what this letter said.
Yes.
By the BSNL on 13th of March 2024. It says, referring to all my letters, emails and all, with reference to the subject and the letter cited by you, cited above, your representation for releasing of pending payments for various works under BSNL Electric Division is received in this office on dated so and so through email. It is requested by you for settlement of pending payments by the department BSNL at the earliest. It is requested by you for appointment of an arbitrator. The EE Electrical Division with a letter was directed by undersigned to settle the case and to resolve your request disputes at the earliest. A latest meeting of EE Executive Engineer with your good self also held on so and so to resolve the said dispute. Further, as per your request or appointment of an arbitrator, it is informed that you have to complete all the procedural steps as per terms and conditions of the agreement. It is requested to exhaust all the steps. Agreement clause 25, so and so clause, so and so clause.
Therefore, if there is a pending disputed bill, they are willing to settle, go and settle with them. You want to reopen everything. That is what the dishonest intention is.
Let's allow me to complete this. It says,
How many
and
times
if
you
not
will allow to
satisfied,
complete now?
then there is a provision for conciliation with the superintending engineer. Even if not satisfied and the dispute remains, you may request the chief engineer for appointment of an arbitrator. This is a letter for appointment of an arbitrator as mentioned above after following all
Or
the
an
necessary.
executive engineer's letter will revive everything.
My lords, what I am saying today is, as per BSNL itself, like the debt is existing, my lords, and it needs to
This
be
kind
settled.
of collusion also
And-
must curb it strongly.
My lords, if it had been collusion, I would not have filed an arbitration application. My lords may just see section 18 of the Limitation Act, what it says. And my lords have interpreted where there is an acknowledgement of that. The mere fact of acknowledgement of existing debt diminishes the running period of limitation, my lords. May I just read section 18? It says,
The work
effect-
is executed in 2010, claim is settled in 2012, all payments received. Suddenly you start some hobnobbing with some executive engineer, probably you are trying to revive everything.
with due respect, my lords, claim is not settled in 2012, it is in 2020, my lord. That's what I have been at pains to, my lords, to convey, my lords. The High Court,
Notice
yes.
to revive
No,
everything.
no, 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 no. The 2020, it is settled for the first time.
All right, thank you very much. Thank you.
My lords, the High Court has recorded it incorrectly, my lords.
We have learned.
And there are 8 contracts, my lords. I'll be completely remediless, my lord. After all, what I am seeking is, my lord, just reference to arbitration, as per the.
Taken by the High Court to the extent that the claims so to be raised by the petitions being a dead claim cannot be allowed to be revived through the arbitration proceedings, warrants no interference. Consequently, the claim regarding appointment of an arbitrator has rightly been declined. However, it seems from a communication dated 18th January 2023 in bracket annexure P7 that on account of some clerical mistake committed on the part of the petitioner while submitting the one of the bills, there is a doubt in the mind of the authorities with respect to certain payments. The authorities are inclined to consider the petitioner's revised bill, the petitioner's claim regarding payment of that bill, provided that he submits corrected and verified bills as per the contents para 2 of the said communication. So it goes without saying that if the petitioner submits any revised bill to the satisfaction of the authorities, his claim regarding the left out payment, if any, shall be examined by the competent authority.
Let's may give the liberty to.
This dispute will not allow the petitioner to revive the, however, this release of this payment or the release or denial of this payment will not revive the cause of action for the petitioner to seek appointment of an arbitration in respect of the entire contractual work which stood completed way back in the year 2012. And
Grateful.
May I please, Your Honor. My lord, the party writes, my lords, to the returning officer. Thereafter gives an FIR that, my lords, that the AB form has been stolen. And my lords, when the party does not want to contest, somebody, my lords, tomorrow, my lords, everybody will go and apply to the returning officer saying the party has permitted me. And then FIR is lodged. Your lordship may kindly, my lords, for a second look at page.
what is known as election dispute? What will be left for the election petition then?
This note, I have a problem here, my lords. I am remediless. My lords, because.
You are not remedy.
My lords, because, my lords, rejection of a nomination, my lords, I can't go there.
Yes,
My
rejection of
lords,
nomination under
It's
section.
not a rejection. That's
You
what.
have very good grounds.
My
for
lord, it's
raising.
not a rejection for, my lord, case is, it's not a rejection.
It
My
is
lords, I could have gone only if there is a rejection.
illegal acceptance of nomination is also an
Also
illegal.
good.
dispute.
My lords, your lordship may kindly look at this. My lords, kindly look at this way. My lords, as far as this, once I go up and file an election petition, which is totally barred, my lords, that is our understanding is that because for the simple reason, my lords, for the simple reason that there has been no rejection. Here is a case, my lords, a case of illegal nomination. BJP party writes a letter to the returning officer that we are not intending to contest. The form which we had given is not right. It has been stolen.
Party take action if they are disowning a
My
candidate.
lord, it's not taking.
My
People.
Even the
My
Hon'ble
lord,
High Court
people
itself ought
can't-
not have issued notice.
My lords, people
He
can't be
challenged-
compelled to vote for a party which does not want to contest today. My lords, look at the position here. Ultimately, my lords, I am in an alliance that apart from the fact that, my lords, ultimately it's the right of the voter. Today, my lords, when the party comes to the court and party files an FIR, tells the returning officer repeatedly, right from the day one, my lords, right from third, on the day of the nomination itself, we objected. It's not that we went late. My lords, on the date of the nomination itself, there was a letter to the returning officer, both by the party as well as by the candidate, saying you reject the nomination for the simple reason that we are not given him the papers at all. My lords, today, my lords, the position would be, in every case, my lords, there could be cases where you simply form any form A or B. Thereafter, the party says that it is not my form. Under these circumstances, my lord, the constitutional court is bound to look into it. Most submission is like this. These are all the rights of an electorate.
It's not referring to the I have dismissed.
My lord, secondly, my lord,
Much of great.
Let it be subject matter.
Secondly or thirdly, now everything is over.
Even writ
Well,
itself
no,
not
well,
maintainable.
well, then one request, my lord.
Thank to local
No,
body
no,
election in
let
Maharashtra,
it
there
be
is a
subject-
bumper crop now.
Well, let it be subject to the outcome of the writ petition, my lords. Because ultimately they had issued notice. That's still.
We are not saying
Doubts
anything.
about the maintainability.
Even
No,
that
no,
itself
my lords,
formed
that will
entertaining
unpick
a
out
writ.
because the court has issued notice.
Out there.
No, that's what, my lord, this should not come in the way. That's subject to the outcome, my lord. That's the only
We are
thing.
not, we would be inclined to hold that it is not maintainable.
No, my lords, that's what the court will decide, my lords.
We will not give you the
Let them take a
protection.
defense.
We will
My
not
lords,
give you that
If you
protection.
want to withdraw, we can permit.
my lords, we'll withdraw, my lords, in sections. Withdraw.
Much of grateful.
My lords,
Case for some time.
and pursue our remedies. Lordship may say, we pursue our remedies.
It may be withdrawn.
But unfortunately, my lords, both the parties are here. My lords, one party doesn't want to contest, other wants to contest. I am stuck.
Thank you very much, thank you.
My lords, your lordship had given me liberty, my lord, to move the.
We are not saying anything.
No, my lords, no, my lords, your lordship had said that I'm permitted to withdraw.
Now, we will dismiss it with cost, that's all.
Permitted to withdraw, my lords, lordship.
But permit to withdraw is all right.
Very good, very good.
Much of great.
In Maharashtra municipal, these local body elections,
Right.
thankfully have brought a bumper crop for the bar. We are very happy to see.
Well, it's like ultimately, well, because of the lordship's order, after 9 years, we are having elections. And ultimately, it would not have happened at all.
Every day.
The election is on 15th, Lordship.
15.
My lord, yesterday also, your lordship, my lords, deferred it by 2 weeks, my lords. Things could be resolved, my lord, extended.
Now we are only repenting that why we extended the date.
Very good.
Lord, this is the Chhattisgarh thing, my lord. The Chief Justice is aware. Now, my lord, respect of,
FIRs are there, Mr. Rao. We
Yeah,
don't
just-
find case of multiple FIRs.
Lord, just see the problem. Lord, at the outset, in regard to a co-accused with the same prayer, my lord, this is the lordship's order, this court's order. Can you just see this? And then,
Three, in fact, three of them. There are others. Three co-accused in that order. Three co-accused in that order.
my lord, just have a look at this. For three co-accused with identical prayers, your lordship will find writ petitions are mentioned. Three co-accused, one is Tuteja, my lord, and one is, my lord, another gentleman.
290 and 290.
Your lordship find three petitions. Your lordships have, my lord, issued notice. Unfortunately, Justice Oak, my lord, is retired and therefore it hasn't come up.
Tuteja is probably, that's, this is also Chhattisgarh.
Yes, same. Now, my lord, on merits, my lord, I want to tell your lordship. My lord, I am a retired officer of the Chhattisgarh government. The allegation is, my lord, that I and a large number of people, my lord, the Chief Justice is aware, 29 other officers were granted interim bail by this court, my lord. That, my lord, we were, my lord, a part of a scam by which the prices of the liquor were increased, my lord, artificially, the customer would pay double and a part of that money, my lord, in cash would come back. That's the nature of the scam. So, my lord, I am in jail, my lord, in Chhattisgarh. FIR, we are registered, my lord, is at the instance of ED under section 66. My lords are aware.
But the problem with in this case, you have in Chhattisgarh, there is only one FIR against you,
Yes,
right?
yes.
It's not a case of multiple FIR.
No,
Now, problem, the other FIR in UP,
Yes.
the allegation is not identical.
Below, with great respect, Lord, it is identical. I have made a chart for your lordship.
Part of the same transaction.
It's a, below, the transaction is like this. A say, Lord, bottle.
Same.
What?
That as a liquor syndicate or mafia, whatever they are using the word.
No, Lord, I will tell you that they are identical. If your lordship will see, I have reproduced it, Lord.
Let's see.
There are charge sheets, Lord, in both cases. Everything happens in Chhattisgarh.
And I counted it was being sold. That is the only allegation in this.
So 272, 271, the view taken by this court in case of Hon'ble to Teja.
Yeah. Yes, Lord. That was quashing.
In the case of questioning also, that the observation which I was just making,
Yeah.
that very view has been taken by this court.
That Lord was
In
in
this-
quashing.
Hmm?
That was in quashing.
No, maybe question.
That is the quashing case.
Sir, please see 273,
Yeah, Lord,
second
I've seen
last
that.
paragraph.
I've seen that. I've seen that.
Because the TT Anthony argument was advanced that they are merging together. So it's a second FIR to be quashed.
But that was for purpose of quashing, Lord. The court is not exactly considered. I've, Lord, if your lordship terms.
It's overlapping on the prayer for transfer that they are state specific offenses.
Transfer is separate. Transfer is below this matter order I have shown. That's the transfer order where notice issued by Justice Oak's bench.
True.
This quashing below was rejected. Justice Sundar
Justice Oak's bench order admitting transfer was in July 24.
which is still pending.
Now the quashing petition gets disposed of by a coordinate bench
Correct.
in September 25,
Correct.
making certain observations which impact the plea for transfer.
But
Because you are saying that the transfer, because the allegations are same or similar,
Lord,
but the coordinate bench says that they are state specific.
there is an order which says that the transfer will be taken up after this quashing order.
Naturally, if it is quashed, what is
I
going to
understand.
transfer?
But Lord,
This will
if I may explain in 1 minute. Obviously, it is state specific for the reason.
I don't think we can do anything.
Let me give your lordship the reason. The reason will not allege is this.
They will also have to be heard.
Yes.
In the normal course, we could help an accused, collect that if you have two identical FIR in two states, or like
Correct,
one track.
correct,
In first, in the UP case, the allegations are different and rightly held by Justice Sundar also in that paragraph. In fact, when you read the FIR, read the charge sheet, the allegations are different. Some allegations are overlapping, but there are different allegations also. The other important aspect is that in the UP FIR, there are co-accused who are state of UP. If your trial is transferred in your case, how can trial, they will also.
All accused are there also. Just have page C.
All accused plus accused who are only in the state of UP.
No, my lord, no.
Yes.
Would your lordship see page C for 1 second? All accused are. Page C.
Yes.
And I'll answer, my lord, the Chief Justice's first query. Whether they're identical or not, I'll answer that. But for the second query, turn to page C below.
Page 3 of
C for Calcutta.
Synopsis.
The synopsis, the petition. Page C. Your Lordship will note, both are registered on the basis of a letter under 66 sent by ED to register an offence. Both the offences are mentioned. They are identical nearly. Now see, my lord, the third accused. All persons accused in the UP FIR, including the petitioner, are arraigned as an accused in Chhattisgarh.
Yes, what about the other accused? You may be.
They are both.
That is not the question.
I said all accused.
No, please see where are the, you just compare the FIR.
Yes.
It is not.
Yes.
And rest of them are not before us. So at the instance of one accused, if they want to face trial in UP, how can we do that?
Right.
36, page 36.
Kindly turn to page 36.
You see, at page 84 itself, you will see second petition is by a person who is resident of Greater Noida.
Page 84.
Page 84. First petitioner on the top is Naranjan Das. You are the first petitioner. Second petition attached with you is a person Vidhu Gupta. He is a resident of Gautam Buddha Nagar, UP.
He is a party lord in UP also is an accused.
But point is that he is a resident of, you are resident of Raipur.
I am a resident
So one can understand that you want your trial to be transferred to Raipur, Chhattisgarh. But what about the person who is a permanent resident of Noida? He will say, transfer my trial from Raipur to Greater Noida.
But he will also have to face trial in Chhattisgarh. He is also accused there. It's not that he is an accused only in UP. I am dragging him there.
Therefore, he will say that the Raipur trial, please transfer it to Greater Noida. Don't force me to go to Chhattisgarh. Chhattisgarh trial, why don't you transfer to Greater Noida? What will happen in that? These will be conflicting claims of the co-accused.
I agree. But the fact is, my lord, I am accused in UP. The UP chap is also accused.
You can be granted some ancillary relief, like suppose the trial is going on. One can exempt you from personal appearance in UP trial. You can be permitted to appear online unless you are required to appear there. You can be allowed to appear through.
So, I understand. May I only say one more?
Otherwise, please see predicament. We will land up in passing an order which unwittingly will cause, if not irreversible loss or damage, some great hardship to the other co-accused.
May I also say, my lord, the view that your lordships are taking will also affect, my lord, Tuteja.
And three others.
No, that.
And three other people.
Will also have to be heard.
Would your lordship then, my lord, call these matters also so that they are also heard?
Then dispose it.
Otherwise, what will happen is, my lord, your lordship may list it before your lordship's court, my lord, on Monday.
Post this matter on Monday. Petition civil criminal number.
There are three of them, my lord, three petitions.
291.
Your lordship find three petitions, my lord. 291 on the top.
290, 291 and 292.
291, 292.
24 are also directed to be tagged along with it.
Lordship.
The registry will inform the parties in advance.
Lordship.
Grateful.
In item 10, I have circulated a letter on behalf of the petitioners.
That is also unfortunately.
Folder.
From 10, there is a letter circulated.
My lord, I am appearing for intervening application.
All right, Mr. Bhagantri, but there is a letter.
It may be allowed, my lord.
Yes, yes.
Lordships are listing it next week. Very well.
May it please, my lord.
Yes.
My lord, in this matter, my lord had lordships had given me bail, first interim and then final to see my conduct. Now, lordship, nothing really survives in this matter. Lordship, the bail may be made absolute. Even the status report of the state doesn't indicate anything which they are even alleging against me in terms of conduct. In fact, the High Court has now quashed this FIR, but that's a subject matter.
Against the court.
They are waiting for you to go. Say the petition was granted interim bail, wide order that it's also. The matter is pending since then. There is no allegation of misuse of the concession of interim bail. The trial is going on. Some of the trial is going on. The cross-examination of PW3 is underway. In such circumstances, and without expressing any opinion on merits, the interim order that it's also made absolute. In some conditions, then disposed of.
Same conditions, my lord says. The same conditions that my lords had imposed earlier, as relaxed in whatever.
Stand disposed of. It made absolute subject to the conditions already imposed therein. The petition stand disposed of.
No, the conditions are continuing, Mala.
Whatever they were there, those are standard conditions only. With Mr. Sibal, every time getting one condition relaxed, second relaxed, and now there are only standard conditions. That's it. There is no condition hardly left.
He is informed the IO wherever he is going. In any case, he has to do that.
Already order is there.
That the court has imposed, Mala, that's fine, Mala.
That order is already there.
Lordship, the order, Lordship had indicated that he has to inform the IO every time he moves out of Lucknow. So that's a little onerous. Whatever condition the trial court imposes, Lordship.
He will inform the IO as and when he leaves the state of Uttar Pradesh. Now you go beyond Lucknow. So like.
Item 12, I am cooperating with the investigation, my lord. After my lord's interim protection, my lord, there is nothing.
My lords, as per the instructions, he is cooperating. My lords, if I may just submit, my lords, this is a special act, my lords, so this may not be treated as a precedent because, my lords, this is the Excise Act and 59 bars.
Landscape Council fairly acknowledges that pursuant to order dated 3rd November 25, the petitioner has joined the investigation. Has joined the investigation and has fully cooperated with the same to take it to a logical conclusion. That being so, and keeping the peculiar facts and circumstances of this case, the interim order dated 3rd November 25 is made absolute. This, the specially petitions stand disposed of accordingly. It is now clarified that this order per se shall not be a precedent to be followed in the other case.
Please, my lords. My lords, may I give a physical appearance, my lords? My memo is not on record.
Oh, yes, you must give.
Please, my lords.
Presence also.
My lord, page 2, my lord, the execution of the sale deed is admitted. Now the sale deed clearly states that my lord, just because I am a clerk in the court, I have procured the order. My lord, these are all disputed questions of the fact. In a similar matter,
Anyway, ultimately, only inquiries to be held, the truth will come out. That's all.
my lord, look at what the High Court has presumed that the sale deed is wrong. In fact, when inquiry has been ordered against me, when inquiry has been ordered against the judge, if the first order of injunction is on the basis of the sale deed. The sale deed clearly, Your Lordship, I kindly see the sale deed. Please.
If we don't pass this kind of harsh order, how the public confidence in judicial system will remain intact?
Madam, the order, as far as the order is concerned, now if I go on the order on the merit, Madam, page 51, your lordship may kindly see the sale.
As far as merit part is concerned, now that you are facing a departmental inquiry, everything will come out. You will lead your.
In the inquiry, it is presumed that it's a procured order because I am a clerk working in the court.
Yes.
But that is, it's entirely. Because I am a clerk working in the court, the whole administration is, I have procured, the courts are favoring me, but this is the presumption the High Court has gone. If your lordship may kindly see page 2 for a moment. Please see page 2. Well, it's a question of my whole career.
Yes, I got very lenient. This was a fit case to invoke proviso to 311 and send you back home. With your dismissal order. What sort of?
See page 2. The petitioner, she has admitted the execution of the sale deed by her husband. And please see the sale deed. It is not a case that sale deed is forced. Sale deed, your lordship may kindly see page 51. The sale deed clearly states that the petition has been.
It is sale of a joint property.
Mala, joint property which is in the possession of the seller. And she is the wife, that is the portion which is the.
Are the co-owners confirming party to the sale deed?
Mala, page 2, your lordship may kindly see. Page 2, which portion her husband is selling.
Co-owners are not signatories to the sale deed. So your statement that your vendor was in exclusive possession is not admitted by them.
My lord, of the portion of the seller, which is in the possession of the seller. Your lordship may kindly see page 2. That's what I'm referring.
Joint property, everyone has equal right to possession of the property until partition.
And possession is foreign on behalf of every co-owner.
But if some other co-owner comes, that is also can be acceptable. But this is the petitioner that she claims through her husband.
And we have
no independent right.
We have never seen an order of restoration of possession, mandatory order of injunction without notice to the other.
There is no order of restoration of possession. The court did not pass the order of restoration of possession. The court had passed the order of protecting my possession.
Not only did the court pass an order of restoration, it directed the police to immediately implement it.
No, my court directly implement the earlier order. If you not, with due respect, well, it's a very, very serious matter. The question of my whole livelihood. Well, just because I happen to be a clerk, please see page 2. Page 2 of this, she admits that she is in possession of this particular portion and she has no independent right. She is only claiming through her husband. And her husband has sold it. Her husband has sold it and given the area which is in his possession. And this is the area which is in possession. Please see the sale deed, page 51. The sale deed is admitted. She clearly admits. Please, for your lordship may kindly see page 2 of the judgment. It is stated she admits the sale deed, execution of sale deed. And page 51 is the sale deed which clearly states that the possession of the property in the possession of the seller. And this property is in the possession of the seller. And when I file the suit, my lord, the court protect my possession, grant a stay in my favor. My lord, her husband files a wakalatnama. He appears in the case. And after that, the police go and investigate the matter. The police visit this and she misleads the court, High Court, that she was not even aware when the police came and thrown her out. Well, this is a totally wrong fact. They have approached the court with unclean hands. They were aware of the order. They didn't file any appeal. By totally misleading the court, they have procured this order. But I am a clerk because simply that I am a clerk, that the whole administration under my bag and call, this is what the High Court has presumed. And on the basis of that, inquiry proceedings against me, disciplinary action against me for this, and handed over to them now by the order of the High Court. But after handing over the possession, disciplinary proceeding against me,
Yes, yes.
Then disciplinary proceeding against the judge also. But this is what this is very harsh.
Why are you defending the judge? You are not holding this kind of element in. Do you think that they should be allowed to stay in judiciary even for a day?
Mala, with due respect, if your lordship may kindly say, the order which I'm only saying, that it says it's a procured order. Mala, if the order is illegal, then it's procured. If your lordship may kindly see the order of 27 January. The order only 27 January.
It crosses all parameters of an illegal order. It's a pervert order.
Mala, that order
Obnoxious order.
Mala, that order protect my possession. Sale deed says possession has been handed over, and the order of injunction says that his possession is protected.
All because of your abuse of the position and out of greed and dishonest intention that you have led to now spoiling the career of a young judicial officer also. That's all.
Mala, with due Mala, even in the writ also, they don't say that this order is wrong. They don't say. Mala, subsequently, if your lordship may kindly say, Mala, this is too harsh. When this is spoiling my whole career. Mala, I have paid the money. And in fact, in the writ petition, even the sale deed has, in a way, has been cancelled. The manner in which the High Court has passed order. Now, your lordship may kindly see that as far as they have to prove it, that as per the possession has not been handed over, they have to prove it that the sale deed is wrong. But the registered sale deed and specifically mentioned, the High Court does not consider it at all. If your lordship may kindly see at page 8, para 11, I have specifically said High Court take note of it. This fact that the possession is handed over to me and the sale deed is a registered sale deed. But the High Court doesn't deal with it just at all. But as far as this, as giving back possession to her, that can be. But as far as going further, in a way, passing out in such a way, cancelling my sale deed, in a way, ordering the disciplinary proceeding against me, this is a too harsh a order. Too harsh a order. In this view of the situation.
Sometimes, occasionally, we must pass very harsh orders also.
With due respect.
So that a right and correct message goes.
If I may ask myself, when a person goes to the court, say that this is my sale deed, possession is handed over, the court, it's natural that the court protects the order of protection of the possession. This is a normal order. The court passes. Yes. And that is what the order has been passed.
Appreciate when the courts do it in the case of an ordinary litigant who is stranger to the four walls of the judicial court complex, who comes there thinking that it's a temple of justice, and where the court grants this kind of relief, we appreciate that. But when the roots of a conspiracy takes place within the compound of the court, and an official who runs the writ there, if he is hobnobbing, and the judicial officer, unfortunately, out of misplaced sympathy, goes on misusing his judicial power, passes an order, this is what the High Court should do.
With due respect, the High Court has presumed that because I happen to be a clerk not in that court, in another court.
Yeah,
I happen to be a clerk in the copying section, my lord. In the copying section, so therefore I have procured the order. This is too much to presume this thing.
Now, thank you.
The order is illegal.
Mr. Fulka, we have heard enough now.
My lord, as far as this part is concerned.
We have heard senior counsel for the...
My lord, as far as this part of simply proceeding against me.
We see no ground even to change a single word in the impugned judgment of the High Court. Instead of having regard to the gravity of the issue and the facts having been brought on record, the High Court was absolutely justified in issuing the desired directions. No case to interfere in made out.
Well, I am being penalized just because I happen to be a clerk in the.
Thank you.
Your lordship, I kindly with due respect. My whole life is ruined.
Let it be. We are
my whole will be ruined, my lord. I have lost my money. I paid 15 lakh. It's not a case that I didn't pay 15 lakh. I have paid the money. The sale deed, I have bought the property, my lord. A clerk in the court is not entitled to buy the property.
Thank you.
My lords, I appear for the respondent caveator that presence may be recorded. I'm so grateful.
Mate.
Sir. Just a minute. Then first, you granted, heard learned counsel for the appellant as well as learned counsel for the contesting respondent who is on caveat. The incident appeal is directed against the impugned judgment at of the High Court of Judicature at Allahabad. So we have gone through the entire report with the able assistance of the counsel for the parties and have used the particulars facts and circumstances which prompted the High Court to issue the unusual directions, only to reinforce the trust and faith of the people in the judicial system. Full stop. From the in the having regard to the facts on record, we are satisfied that the directions issued by the High Court are befitting to the issue which came up for consideration, and none of the directions, none of the observations or consequential directions issued by the High Court warrant any interference by this court. The civil appeal is accordingly dismissed.
My lords, may I just
If
slightly
your lordship may
correct-
kindly see, the suit may proceed on its merit and the inquiry influenced by the orders of the High Court.
My lords, the petitioner has still not deposited the cost which has been imposed. It
What
was.
he will do,
Please, my
he must be waiting for the dismissal of this petition.
Please, my lord. I just wanted to.
If your lordship may kindly see, the suit will proceed on its merit and the inquiry also against me, my lord, without.
That High Court has already said so.
No, my High Court had not said so.
It is implied
If
that.
your lordship may kindly see.
Thank you very much.
My lord, the inquiry, if it will be taken as a direction that I should be hanged. My lord, if your lordship may kindly see, inquiry as well as the suit may proceed.
Can only direct the High Court to hold the inquiry on day-to-day basis against you as well as that judicial officer, both.
Well, as far as the suit is concerned, your lordship may kindly see suit may proceed without prejudice to this order, my lord.
The suit will proceed in accordance
Well,
with law.
High Court had not said so. Your lordship may kindly see the suit may proceed uninfluenced by the order of the High Court.
Thank you, Mr. Cook. I will not say anything.
Please. We are having a problem. Chhattisgarh, my lords, for the office bearers. My lords are, it's really a hand-holding exercise by this honorable court. It's all going on, my lords, in a certain manner.
Issue notice. What is the date in other transportation?
In the 20th, my lords.
Dusty for 20th. Also tag with. Meanwhile, an order has been passed or still pending?
The High Court has said within 48 hours I have to give a response, and it's proceeding further, my lords.
Meanwhile, further proceeding before the High Court shall be ministered.
Deeply obliged.
Please, your lordships. Please, your lordships.
Yes, please.
We've received the last tranche of 40 crores. It was encashed somewhere in the December, middle of December. So the original order which your lordships had passed that the 250 crores be transmitted by 28th February
That you have received.
2025 is finally received in the middle of December. Justice Dave's report is now available. We would like to file our suggestions to Justice Dave's report.
My lord, the report was received quite some time back, my lord.
So
It's a July
Only
24th
my learned
report.
friends have filed some suggestions to that. Rather,
But this report is received on 9th
yes,
July.
but 9th July. Our lordships had seen that the money had still not been forthcoming, so we didn't know where it is going to reach.
So let's file whatever suggestion.
That's
in
right,
due
that's
course.
right, your lordships.
The counsel for the respondents informs that the amount of rupees 250 crore has been received from the petitioner. He seeks and granted 1 week time to submit
Lordships
suggestions.
may grant some more time because it's a large report and it's a huge transaction.
It's not a large, it's a very short report.
Have you seen the report?
I have. The only thing is,
This I just only for cursory look. You are entitled to certain payments pursuant to that. If the matter can be disposed of, we will grant you that.
very well.
The respondents are seek and are granted 10 days time to submit their suggestions for my penny. On the report of Justice Anil R. Dave, former judge of this court, on the report dated 9 July 25, submitted by Justice Anil R. Dave, former judge of this court. post this matter list to the non-Muslims way, 1 week के बाद next week में.
One submission, my lord. Not that I'm arguing the matter today. Lord Keventer, who's, my lord, also, my lord, funding us.
We have seen your application, but that can order only in final hearing, final
Yes,
order.
but only thing was Keventer was saying that your lordships had made an observation that we will be entitled to the charge which SBI will release. So they only want quantification so that, my lord, funds can be released. They should know the exact amount and that they will get a charge which the SBI will now release because they've released the entire amount.
That is what your application also says.
That's right, my lord. That is all, my lord. They just wanted, my lord, that.
Once the SBI's liability is discharged, then obviously your lender will have the first charge there on the property.
That's right. That's all the, my lord, clarification is wanted, my lord, and they are willing to fund us for whatever amount is quantified by this court, my lord, as per Justice Dave's report, my lord. That's the only clarification, and we can, my lord, argue on the issue as to whether, my lord, they are entitled to anything more than what has been indicated there.
So this, do you require this? It goes without saying. It goes without saying that as soon as the SBI's liability is discharged,
It'll be CFM.
My lord, it'll be now CFMRC because they are the assignee of SBI.
Respondent to.
They are the assignee of SBI. SBI is
assignee of
CFMRC.
Liability is discharged. The new lender, in bracket, Keventer Capital Limited, will have a charge on the property.
I only point out your
Already
lordship, it's
more
a
similar charge.
SBI.
It's a pari passu charge, actually. Yes, it's
A similar charge. That's why
the other lenders also.
It's only probably somebody who is now providing them finance.
That's
they want to secure their
It'll be a
interest.
pari passu charge, not a first charge.
And better it is because otherwise, if suppose they again create some third party interest, it will unnecessarily create.
I'm also wanting a similar charge as SBI. I'm not wanting something more. my lord.
May I only beseech your lordships for a little more time than a week? May I beseech your lordships for a little more time than a week, just 2 weeks to file the suggestions, and your lordships may then take up the matter.
If you need for 2 weeks, what we said, you please on Justice Dave was appointed on your asking.
That's right.
Right?
That's right.
And probably, of course, we have not examined so minutely that when after your suggestion comes, he has done a commendable job trying to balance the rights, holding you entitled to certain monetary benefits to your advantage. We will determine that whatever.
Lordships, given 2 weeks, 2 weeks to file our suggestions. That's it.
2 weeks and then list of immediate after 2 weeks on a non-miscellaneous.
Deeply obliged, Lordship. Deeply obliged.
Lord, your lordships have said similar charge as SBI. Your lordships have said that. my lord.
We have said, I think we have said that if the assignee of SBI is liability is discharged, then your new lender will have a charge on the mortgage property.
Will have a similar charge, but whatever charge they.
Will have a similar charge on the mortgage property.
Lordship, please.
Yes. Deeply obliged.
We hope you are not duping your new financer also.
250 crores, your lordship, because, my lord, it's not a small amount which we have paid over.
14 millards, these are a batch of 5 SLPs. These are a batch of 5 SLPs. In the first SLP, the respondents have filed the counter affidavit yesterday, millards. Lord, I'm seeking some time to file my rejoinder, milord, in this matter.
Oh, Lord, let it file. Counsel for the petition seeks and granted 2 weeks time to file the rejoinder.
Lordship, give me 4 weeks, milord. So,
Rejoinder 4 weeks. Got it.
yes, milord.
Very
Grateful, milord.
Milords, I'm seeking a passover, Milords. We are being led by Mr. Tanka. He's on his legs in court 5, Milords.
They just stay against us, my lord, so long as lordship may take it up, my lord, before, because 2 o'clock there's a different bench. So they just stay going on against us in an election petition. So, my lord, lordship may consider taking it up, my lord, when Mr. Tanka comes before the, because, my lord, otherwise, my lord, it's a 711 application which has been dismissed by the High Court, and in which he admits, my lord, there are corrupt practice, but affidavit is defective. And he did not know that there were criminal cases against him. So this is a matter of trial. If your lordship kindly see his application, my lord, page 286 at 292, he admits, my lord, that there may be cases of corrupt practice.
Volume.
Yes, Mr.
Volume.
Please, Your Lordship.
Lordship, I have the order dated 3rd of November, Lord. So the principal issue was not 3G and 3J has been declared constitutionally void.
But why you are shown so great hurry in withdrawing those petitions? You yourself have invited problem.
We have not withdrawn any.
No, we have not withdrawn, no.
No. After this Justice Thakur's judgment, you should have waited for some time. Everybody comes in appeal, take a chance, but what will happen? You have unnecessarily withdrawn.
No, that is an independent application by some other person.
Lord,
Your Lordship have already protected us, my Lord, by the interim order saying that. Your Lordship have already protected us by saying that all proceedings to continue. That is an interim order by Your Lordship. That is the first order, my Lord.
30th May.
30th May order, Your Lordship. That is already there, my Lord. So proceedings as of today are continuing, but ultimately this judgment, my Lord.
No, there is one LU by Anand Prakash Verma.
Please,
on behalf of 21 landowners.
please, Milord, I'm appearing in the IM for intervention and for limited direction. Because their objection petition for arbitration
You
was.
don't file your own SLP, and you, where was the hurry for you to withdraw your arbitration petition?
Milord, they were withdrawn because in light of the judgment, impugned judgment.
I could take a judgment. People wait for the Supreme Court outcome of those proceedings, and you rush so fast.
Milord, they were not aware of this. They were not aware of these developments.
Anyway, who is appearing for NHI?
No, we are the petitioner.
Lord Solicitor General was appearing, my Lord.
Which matter? We are talking of IA.
they are defending me.
There is an IA number 10268 of 26. It can't be 26, 26, it must be 25. चेक करो ये हमारे ऑफिस में ऐसे कर देता है. There can't be 10,000 IAs in 2026 in 2 weeks.
Lord, may I seek your Lordship's indulgence in this matter, ma'am? I represent the private respondents at whose behest the act was quashed. We are not standing by that quashing. I already addressed your Lordship on that. All we wanted from your Lordship was to fine-tune the process of this act, particularly the appointment of arbitrator, etc., etc. And your Lordship had considered that, and I had provided a written note to the union. And the solicitor had said he would consider it, but today there's nobody representing the union, which
Is there anyone who is supporting this judgment also?
No, nobody
is there.
Nobody is
Even we are coming before this.
Neither the petitioners nor the respondents.
Nor the
Nobody is supporting.
actually, Lord,
Even the SLP has also been filed by the Union of India as well in the present case.
The union is
You
also.
need to notice across the border to find out anyone to support this.
So this is what it is.
The landowner want that it is required to be revealed. It's a violative, it's a in the law laid down by this honorable court in the same thing in Nagpur Improvement Trust.
Mr. Bagria, you can't render the people remedyless.
Parallel to that of the RTT LARR Act, my lord, there is the provisions was the same.
Possibly ask to the extent like what happened in Punjab and Haryana, in the Gram Panchayats. Earlier, when the Gram Panchayat elections would be held, and if there is a dispute regarding election, those used to go to the executive magistrate. So there was a movement, there was an agitation, there was demand, and eventually there was a judicial opinion that this matter involved a quasi-judicial adjudication. Therefore, the judicial court should be given that power. So now the acts were amended. Now in Punjab or in Haryana, when you want to file an election petition, it goes to a judicial officer, right? So somebody could say, arbitration clause is fine, but please say instead of the deputy commissioner, the collector, let it go to the at par with the Land Acquisition Act before a judicial officer who holds the reference code.
that is what from your Lordship last time also.
Milord, in that also, Milord, there would be another problem, which is this honorable court suo moto has considered in M. Hakim, which says, Milord, after that, private arbitration again adversely affecting the right of the landowners parallel to Milord section 64, which provide right to appeal. In case of private arbitration,
the clause of section 34 objection is the limited jurisdiction, my lord. Even, my lord, in
But these are not the reasons given by the High Court in this.
My lord,
This has not even gone into, my lord.
my lord,
So far
these,
as,
My lord, so far as the High
Therefore,
Court is
Your
concerned,
Lordship had asked the union to consider all these three things and then come back, but somehow the union is not here today.
is earlier, in fact,
I appear for ministry in item 16.4.
okay. कह दो earlier, medical के लगे earlier ready कर दे.
my lord, moreover, when
Lordship
the
has
arbitrator is
answered
there,
it
my lord,
right up to the Supreme Court
And
sometimes.
arbitrator is the, my lord, the judge of the both the parties. Here, the party which is acquiring the land, appointing suo moto unilaterally. My lord, so that is, my lord has also pointed out in the last order also.
10268 is it 25 or 26? हैं? इतना पहुंच गया ये?
ये इतनी बात.
This application has been moved by one Anand Prakash Sharma for and on behalf of 21 landowners whose lands were acquired under the National Highways Act 1956. The award was passed by the competent authority under that act, and being aggrieved, these landowners, and being aggrieved at the determination of compensation from these landowners filed petitions under section 34 of the Arbitration Act before the Additional District of Bhiwani. While the petitions were at the final stage of arguments, the Punjab and Haryana High Court rendered the impugned judgment dated 20th March 2025, whereby section 3 capital G and 3 capital J of the Act were declared unconstitutional. Consequently, the statutory arbitral mechanism stood invalidated. Also, their section 34 petitions and an order to this effect was passed on 25th April 2025. Meanwhile, this court on 30th May 2025 stayed the operation of the judgment of the High Court dated 20th March 2025. Thus, the arbitral framework envisaged under the 1956 Act again stood revived, though maybe temporarily, as this court is yet to finally adjudicate the legality of section 3 capital G and 3 J of the 1956 Act. So unfortunately, if the applicants file a fresh petition under section, it will be barred by limitation under section 34 in bracket 3 of the Arbitration Services Act. The resultant effect is that the applicants have been rendered remediless. In these circumstances, and with a view to ensure justice to the parties, and with a view to render complete justice to the parties, we deem it appropriate to invoke our powers under Article 142 of the Constitution, and consequently, we set aside the order dated 25th April 2025, passed by the Additional District Judge Bhimani, whereby the petitions filed under Section 34 of the Arbitration Act were dismissed as withdrawn in light of the High Court judgment dated 20th March 2025. As a necessary corollary, all those petitions under Section 34 of the Arbitration Act filed by the applicants stand revived and shall be further heard from this stage. The same were withdrawn and shall be heard and shall be processed further from this stage. The same were withdrawn. Ordered accordingly. The application is thus allowed. Semicolon. The order dated 25th April 25 of the Additional District Judge Bhimani is set aside, and all the petitions filed by the applicants under Section 34 of the Arbitration Act are stand revived. दोनों आई है 10268 and 10325 of 2026. Both can be disposed of by the Commonwealth. That's paragraph. Where the Union of India today?
No one is appearing today. No one is appearing today.
Next paragraph.
Item 16.4 has been filed by ministry.
16, Lord, item 16, 16.1, etc. by the Union of India.
No, but are you there for the Union?
I appear for the ministry, my lords. In item 16.4, Sohan Lalwar.
We are responding.
The issue is common.
Issue is common.
The issue is common.
Stance is also
You
similar.
are also in petition, landowners are also petition.
Please, my lords. Issue is common.
It's only rarely it happens that when both parties have same voice. But this is what exactly it has happened.
Please, ma'am.
So what we are only suggesting you that meanwhile you consider certain things. Next paragraph. Adverting to the main case, it transpires during the course of hearing that under the National Highway Act 1956, the remedy provided to an expropriated landowner stroke interested person, interested party, if such person is aggrieved by the rate of compensation determined by the competent authority, is to invoke arbitration in terms of invoke arbitration under section
3G5.
3G5.
3G5. 3G5.
3G5, read with provisions of the Arbitration Act so and so, so and so. Such arbitration petition is adjudicated not by a judicial court, but by
the executive officer appointed by
By an officer appointed by the NHI.
No, no.
by an officer,
by the central government. By the central government.
by an officer notified by the central government.
By sign.
Central government.
By the NN.
The
That's right, that's right.
All the expenditure is paid by
nominated by the central government.
requiring one.
Invariably, the collectors or commissioners of the revenue districts stroke divisions are notified to act as arbitrators. So, these officers are oftenly occupied with their multiple administrative responsibilities. They also do not have the desired experience of judicially trained mind to adjudicate the complex issues like determination of market value of the land or other statutory benefits to which the affected party are now entitled to in terms of the are entitled to in light of the decision of this court in NHI versus Presumption and others, as well as in light of as well as keeping in view the subsequent amendments made by the Parliament in the 1956 Act. Next paragraph. Not only this, comma, the further recourse left to an aggrieved expropriated owner, landowner, or any other interested party, comma, is to file a petition against the arbitral award, comma, in accordance with section 34 of the Arbitration Act.
My lord, complete appeal, my lord. It's complete appeal is provided under the parallel legislation. My lord.
Filed an appeal under section 34 of the Arbitration Act, comma, followed by a further appeal.
My lord,
Under section 37 before the Honorable High Court.
And followed by a further appeal under section 37 of the Act before the High Court. By now, comma, the restrictive and limited scope of examining, interfering with an arbitral award, comma, by a superior form in perpetual exercise of its powers under section 34 or 37 of the Arbitration Act, comma, as the case may be, comma, has been well defined by this court in a pattern of judgments. Next paragraph. Contrary to it, comma, the expropriated landowners, stroke interested persons whose lands were earlier being acquired under the Land Act 1894, comma, were entitled to seek further enhancement through a reference under section 18 of the old Act, and such references were decided only by the judicial courts comprising a presiding officer in the rank of district judge, stroke additional district judge. There was a further remedy of first appeal before the High Court, and thus even the High Court had the power to reappreciate and reappraise the evidence and then form an opinion market value of the acquired land. Next paragraph. Such a vista for the landowners, for the expropriated landowners, stroke proprietors, interested party, has been further widened with more statutory benefits and a higher rate of compensation under the provisions of the right to fair so Act 2013. Next paragraph. It may thus be seen that the landowners whose land is acquired under the National Highway Act 1956, vis-a-vis the landowners whose lands are acquired now under the 2013 Act, are in a highly disadvantageous and unfavorable condition vis-a-vis so have been treated as separate classes without any separate classing, apparently without any intelligible differentiation. This also leads to hurt burning, grave hurt burning among the landowners, of the first category, namely whose lands are acquired under the National Highway Act 1956. Next paragraph. While there seems to be a lot of legislative wisdom discernible from the mechanism encapsulated under the National Highway Act 1956, to the fact that the acquisition under this act must take place in a time-bound and expeditious manner so that the development of national highways is not hampered or delayed. Such a policy, legislative policy, is always laudable. However, from a prima facie, it seems that this object can be kept intact while ensuring the landowners that they will be entitled to assessment of compensation for their acquired land in the same manner as is determined for the landowners whose lands are acquired under the 1894 in bracket repealed act or under the 2013 act in bracket new act. On the even for when such acquisition is also for infrastructural development. Next paragraph. So, keeping these factors in view, next paragraph, it appears to us that keeping these factors, we implore and suggest the Union of India to revisit the legislative scheme and consider the desirability of introducing, consider the desirability of bringing parity in the matter of providing mechanism for determination of the market value of an acquired land. Acquired land with reference to Article 300A of the Constitution. Next paragraph. Since the issue falls within the domain of the legislature, we refrain ourselves from expressing any final opinion and leave it to the entire discretion of the competent authority to look into this aspect and take a holistic view. Next paragraph. The Registry directed to provide a copy of this order to the Learned Attorney General of India and Learned Solicitor General of India for the necessary action. Post these matters for further consideration on so and so date.
My lord, in the meantime, the interim order to be.
Learned Attorney, you are here. Oh. Then we request you to examine this aspect. Say, Learned Attorney General of India for India, who is present in court. Say, we have requested Learned Attorney General of India, who is present in court, to look into this aspect. The registry directly to supply a copy of this order. To send a copy of this order to his office for necessary action. Similarly, a copy of this order be also forwarded to Learned Solicitor General of India. Post this matter for further consideration after 3 months on so on so date.
Not only one thing, which in the meantime, the interim order to be continued so that let it be please.
Interim orders to
And
continue.
my lord, while dictating the order at one point of time, you have stated this specifically that amendment made in the national life, but there is no such amendment made in the national life. Rather, the amendment was made was in 1996 Arbitration and Conciliation Act. So that need to be rectified in the order.
No, there is an amendment, I think, by virtue of the 2013 Act. They are in the schedule, the
Yes, they have
Act.
specifically ordinance 2015 ordinance, which they are.
That amount to amendment of.
Please, Lord.
My lord, the other, my lord, difference between both the legislature, 3G5 provide remedy to the requiring body also. My lord, as per section 25 of the old act, which says amount of compensation awarded by court not to lower than the amount awarded by the collector. The amount of compensation awarded by the court shall not be less than the amount awarded by the collector.
Mr. Bagadi, that will be taken care, because once it is brought at par with, then same provision applies. Then
Only 3G5, if my lord consider it appropriate, because section 95 in new act says they can't go for reduction once the amount of compensation awarded. Due to this lacuna, my lord, they withheld the compensation in these cases. I have 4-5, my lord, the matters where the 5 year has gone, they are not releasing the compensation as the arbitral proceedings are pending. So the new act says they, under section 95, they can't go for reduction. Once the amount is determined, they have to release that very amount. There is also, my lord, this is a article.
No, are you talking of the acquiring authority?
Requiring body, my lord.
Are the beneficiary of the acquisition?
Beneficiary, my lord.
Why should we provide for him? If you don't want to acquire, you don't acquire. If you don't want to pay.
No, my lord, the requiring body is not
You
supposed
take
to
away the land of a person.
go
If
for.
you want, I will harass you now by filing appeal that you reduce the compensation.
My lord,
Yeah.
here is the legislature is on the old act and the new act is also parallel to the same.
Legislature will provide, it's all right, otherwise why should we?
New act to the other landowners is saying they can't go for reduction, my lord. It is also violative to that, my lord.
Point out your lordship. There is one statute.
Yes, item 17.
Not
Yes,
just point out to one statute, Requisition and Acquisition of Immovable Property Act, where also an arbitrator is appointed, but the government always notifies a sitting additional district judge. I'm just bring it to their notice. In
that can be done.
It's always an additional district judge, and then an FAO lies to the High Court.
That can be done here.
FAOs, that huge number of FAOs used to come for acquisition of military lands.
Also that government will do.
I have already given a note to them. I'll provide them that copy also.
N number of writs are filed in this way. Please.
Yes, Mr. Attorney.
I'm told the first appeals are being heard by the High Court today. In this matter, the first appeals are being heard by the High Court today.
The main case.
Yes. Therefore, would it be advisable the matter is held over till.
So we can dispose of these matters.
No, I thought in case we have some issue with the High Court judgment, then we can probably bring it up. Your Lordship may kindly keep this matter pending till the High Court dispose of the matter.
If ultimately suppose the High Court partly decides in your favor or the High Court decides against you.
We do not know, because there is an earlier order where we have some difficulty. That's why we are an appeal here today. So kindly await the judgment of the High Court for about a month's time. I think the High Court judgment will be pronounced as early as possible. That would be in order.
Now, if suppose we say that the interim orders are made absolute.
That's right.
Made absolute.
Very
and appeal, the SLPs are disposed of with a clarification that the interim stay will continue for another period of 4 weeks or 6 weeks.
Very well.
I think that will take care of the parties. Why to keep pending these matters?
Well, in terms of the order of this Hon'ble Court, allowed to release the 30% amount, my lord.
Whatever you are entitled to, you that can be released.
We have complied with your Lordship's direction.
My lord, kindly see page 56, my lord. This Hon'ble Court in similar case passed the order, my lord. Page 56, my lord. Page 54, my lord. May I read, my lord? Page 54, my lord.
I'm already infected. This one appeal we have already decided.
2 matter has been decided by this Hon'ble Court, my lord. And my lord, High Court, this Hon'ble Court has directed to release the 30% amount out of the 100% amount, my lord, and directed them to deposit the 50% amount, my lord.
These matters.
Instead of 50%, they should deposit the 30% amount and release 30% amount, my lord.
We have deposited 50% in terms of your Lordship's order, and 30% I think will be.
It would be balanced, my lord.
Other cases.
Which was what is the date of the
So
order
let,
we passed?
as your lordship suggests, let the interim order be made absolute.
My
and-
lord, 3/6/2004, my lord. And 6 was issued, my lord, 4/7/2005, my lord. And award was passed, my lord, 19 September 2015, my lord.
Order.
This case, in this case.
No, that was the.
Page 54, my lord, para 4.
Another matter, Lordship.
Oh, my lord, this is same notification, same accusation, same, everything is same.
Meanwhile, execution proceedings ensue, right, subject to deposit of 50%.
Your lordship's order on 8th of January 2026.
Yes, sir.
8th of
And an
January.
earlier order, yes.
No,
So we deposit 50% amount. Let this, as the lordship suggested, let it be made absolute. And let the judgment of the High Court come in the meanwhile. And then you lordship kindly turn to an earlier order on 10th of November 2025.
In different matters, Lordship, but this batch.
No, I think, Learned Attorney, our order is, one order is, say, for example, of 10th November 25.
That's right, 10th of November 2025.
That has been followed in all matters.
And that order has been followed in all the matters.
That's right.
Say, leave granted. These appeals have been preferred by Bareilly Development Authority against the interim orders, interlocutory orders passed by the High Court of Judicature at Allahabad
This is October 2025.
in pending appeals.
2025. So, 6th October is the first one. Yes.
In pending first appeals, whereby the appellant authority were directed to deposit 100% compensation amount payable for acquisition of the respondent's land. And the respondents were, and upon deposit thereof, the respondents were permitted to withdraw 50% thereof. Paragraph. One of these matters came up for hearing on 10th November 2025, when after hearing both sides, this court was pleased to pass the following order. Para 5, 6, 7. We are informed that during pendency of these proceedings, the High Court has already taken up
Yes,
the main case, namely the set of the first appeal
that's please.
for final hearing. Next paragraph. That being so, we see no reason to keep these petitions, these appeals pending. These appeals, directed against interlocutory orders, to be kept pending. The same are accordingly allowed in part. The impugned interlocutory order of the High Court is substituted with the order, interim order dated 10th November 2025 of this court, as reproduced above. Next paragraph. It is clarified that we have not expressed any opinion on merits of the case. Next paragraph. It is further directed that the interim stay granted from 10th November 2025, which is made absolute today, shall continue to operate for a period of 6 weeks from the date of uploading of the final judgment by the High Court. Final judgment of the High Court, so as to meanwhile enable the aggrieved parties to approach the appropriate forum.
Your Lordships, I may
My lord.
make only one request. There are two connected items on behalf of the
Mainly
state.
direct the High Court to decide the matter within, my lord, stipulated time, my lord.
There is,
I'm told the matter is being heard
in our
today.
news
Yes,
we were
you are
directing to the
right.
High Court. Next paragraph.
The matter is already part heard before the High Court.
The High Court has already commenced hearing in the main case, वहाँ पे कर देना, and the matter is likely to be decided very at the earliest, when we don't necessarily keep it going. We have indicated at the earliest.
My lord. In the meantime, my lord, allowed to release the amount 30%, my lord.
That whatever order is already.
If I may only make a request, there are two connected items on behalf of the state which are part of this batch in which same order is operating. They have inadvertently come up before Court 8 as item 51 today. They're part of the same batch. In fact, common order is a same.
Common order listed where?
This is Court 8, item 51 today. We've made a mention in the morning, but Your Lordship, I was asked to mention before this court when the matter was taken. I have the diary numbers. Same order has been passed on 13th of January.
No, in this very acquisition.
This very
No,
application.
but then if the matters are listed, then you point out to the honorable.
I'll point
bench.
out to that.
Eh?
I'll point.
That this is how we have disposed of.
Grateful.
You just bring to the Lordship's notice.
Grateful.
My lord, only request, my lord, allowed to release 20% for the amount, my lord, at least, my lord.
That already, whatever order is there. Now matter is being decided, you see. It will
No,
take
my
10
lord,
days, 50 days.
misleading fact, my lord, completely, they are misleading this court.
Today made some observations that will help you. You produce this order before the High Court and see.
Very good.
Lord, in this matter, formal notices have not gone, but although most of the parties on the other side are appearing in this matter. Now, the real legal issue is that according to the Lord CRZ notification of 1991, clearly we were not within the Lord restricted area because the area was only 43 meters, which is the length of the breadth of the river at that particular point of time. Now, this argument is specifically taken before the High Court. High Court says, I'll not deal with this because Supreme Court, when the matter had gone against an interim order, has decided something. So we will not go beyond that and we will confine ourselves to what the Supreme Court has said at the interim stage. Now just see the Supreme Court order, Lord, at page 322 at the interim stage. There is a slight dichotomy. There is a slight variance of what the Supreme Court is saying at page 322, Lord, annexure P45.
45.
322, my lord, is annexure P45.
Yes.
At 323, next page. The High Court in its order has given a finding that petitioner has encroached on a lagoon and consequently orders have been passed directing the petitioner to remove the encroachment and restore the lagoon to its original size. Since the writ petition is still pending before the High Court, where several other aspects relating to environment and conservation and coastal management of Goa appears to be still under consideration, we would not go into the details. Yet we must make it clear that as to the present dispute of this lagoon is concerned, it would stand concluded by our present orders here. This is what they say in Lord paragraph 1. Then please see at 327.
Yes.
Para 8. In fact, 326 bottom. There is no point here to discuss as to whether this new round of litigation was a ploy engineered by interested parties to somehow get away and defeat the earlier orders of the tribunal, which had given a different finding as to the measurement of the lagoon and had actually attained finality. We leave this to the High Court, which is still seized up with the broader issues. What is obvious, however, is that this was all to the benefit of the petitioner. The role of GCZMA too is problematic, but even this order of NGT was not complied with till the writ petition was ultimately filed before the High Court. Now, my lord, I'll tell you, lordship, the very small neat point that is involved. Please see page 22 of the impugned order. Page 22 of the impugned order, paragraph 18. Another point of significance which Mr. Rao, para 18 at page 22. Another point of significance which Mr. Rao has pressed into service, Mr. Rao is appearing for us, my lord, is that the order dated 7/4, this is in the final order, that the order dated 7/4/17 is without jurisdiction.
Just a minute, Mr. Vikasi, where are you reading?
Page 22, blood para 18 of the impugned order.
Oh, all right.
Page 22 appeal.
Yes, paragraph.
Para 18, blood, para 18.
Yes, yes.
Another point of significance which Mr. Rao has pressed into service is that the order dated 7/4/17 is without jurisdiction and therefore a nullity. According to him, the Coastal Regulation Zone 1991 came into force on 19/2/91 and remained in force up to 22. There was no provision for a buffer of 50 meters along with mangrove. In terms of the note on prohibited activities of CRZ, he would submit that the application of CRZ 91 in cases of rivers, creeks and backwaters shall not be less than 100 meters or width of the creek of backwater, whichever is less. In this case, Lord, it is only 43. He would submit that in the instant case, the area of the river which abuts the property on the northern side is admittedly 43 meters. And the CRZ 1991 would have applicability only for a distance of 43 meters from the high tide line, which in case of a river is reflected as the highest point on the shore of the river. It is thus his submission that from the above shore of the river on the northern side up to a distance of 43 meters towards the southern side would be the CRZ zone, and activity within 43 meters would be subject to jurisdiction of GCZMA, but it would lack jurisdiction on the southern side even an inch beyond 43 meters. In CRZ 1991, unlike CRZ 211, he would submit that there was no provision for demarcation of buffer of 50 meters along with mangroves, and demarcation of CRZ zone can only be done in the Coastal Zone Management Plan as approved by the Ministry of Environment and Forests. Admittedly, CZMP would depict the classification of CRZ under Clause 7 of the CRZ of 2011, which could be considered for grant of clearance for permissible activities under Clause 4.2. It is therefore his submission that in terms of CRZ 1991, up to 6/9/22, because that is the date when the CZMP plan came along, and consequently even as buffer zone along with the mangroves beyond 43. In short, it is his submission that when the order of 7/4/17 was passed, there was no buffer of 50 meters along with the mangroves, and GCMA could not have exercised any jurisdiction whatsoever on the southern side of CRZ demarcated in survey number 318 of 12. It is also the submission of Mr. Rao that order dated 4/7/4/17 direct the impossibility to be performed, as there is no possibility to accommodate the lagoon in 125/80 in the subject property, that is survey number 318/2, as the property has length of only 120 meters and not 135, which impression was created before the court when it passed an interim order dated 15/3/24. Now, Lord, if your Lordship will kindly see, the CRZ I have already placed on that 2011 is on record. And the learned judge does not deal with that at page 53, if your Lordship will just kindly see that also. She says, because the Supreme Court in the earlier round, that order which I read to your Lordship says Annexure P45, Supreme Court has closed the issue, so we can't get into this at all. Page 53. Sin all, page 53, blood of the same impugned order. Since all the while it is the stand of GCZMA that the lagoon deserves to be restored to its original dimension as was destroyed by the land filling and construction of structures which were clearly in violation of directions issued by GCMA, we are not impressed by the submission of Mr. Rao that GCMA has no authority or competence to examine. It is pertinent to note that complaints against so-and-so as ordered as 15 and we had proceedings so. So really speaking, they don't consider this. And they also say that because Supreme Court has also decided that we will not get into this, that your lordship will find me that page. Para 42, page 55. In the light of the observations recorded in order dated 15/3/24, which is your lordship's order, Supreme Court.
This is High Court order.
In the light of the observations recorded in the order dated 15/3/24 with reference to direction of 7/4/17 issued by so-and-so, which retained finality, which has clearly recorded that existing as so-and-so, directed removing of mud filling and its restoration to the original dimension. This order having been upheld by the Apex Court on 14/5/24, foreclosing the issue as far as dispute of lagoon is concerned, we direct its implementation. That's how, Lord, the impugn order. Now, Lord, the measurements, your lordship, will just have a look at the map, Lord. That map, your lordship, will find in the additional affidavit that we find at page 109. In the IA. IA number is, Lord, 260315. IA 260315.
Page 109.
Yes, page 109 of that, Lord. In this, if your lordship will see, the river is on the top. The width of the river is 43 meters.
No, there is no river here in page.
That I'll just show, Lord. Your lordship will see the other map, the Google image. The Google image is at 351 of the same IA.
110. Yeah. No.
351, Lord, is the Google image.
Where is the river are you referring to?
Pardon, Lord?
Where is the river which you are referring to?
In the Google image, it is clear, Lord. In the Google image.
You can show this photo, 111. Now that they have.
It's 351 of the SLP, my lords.
35. I'm sorry, Lord. This is the SLP. I'm so sorry. My lord,
109 is on the top.
not the IA. 351 of the SLP. I'm so sorry. Now, if you lordship will see 351, the river is on the top, the northern side, the lagoon is in between, and this is a Google image of 2010. What is there at the behind the lagoon, which is towards the resort, is below some small, your lordship will see small hutments type things are built there. That is in 2010. So lagoon, this is the lagoon size in 2010, much prior to my buying the property. Then please see at 352.
Yes.
The lagoon size shrinks by about 500 square meter because of the fact that there is slight construction on this side. Northern side. On the southern side, the houses have gone and a road has come. That's all. So
Black and white photographs are attached always.
Since it's our duty to abide by a lordship's time limits.
Mr. Dr. Singhi, can I just complete? I can understand.
Remind 15 out of the 20 minutes are over. Your lordship has given him their side and our side 20 minutes. We must abide by that. 15 out of the 20 are over. I'll take less.
If I cannot show what the point is, Lord, then your lordship will definitely permit me. Just see, Lord, the Google images at 312. Now, please see the CRZ plan.
The time limit is the order.
Notifications at 69.
That is at page 69.
Just tell them.
Plan. What you showing?
108. 108 of the IA.
108 of the IA, Lord.
8 of the IA. Page 8 of the IA. This is the one.
Just see page 8 of the IM, Lord. Page 8 of the IM. This is page 8 of the IM, Lord.
Seventy at page 7.
No, but come to page 329. This finding, how can we, Mr. Vikasim?
329 of the SLP block?
329, Justice Dulia's operative
That
part.
order I've already read, below. That order I've already read. 327, he says so that this will be final. And then 327, he says that High Court will still go into this. So it's at the interim stage, High Court is yet to decide.
This finding by this court is final. No, that.
No, but Lord, the writ is pending, Lord. The writ is pending. So there is a contradictory portion in the order, because as far as the order, as far as, and if I'm raising, Lord, a purely legal issue with regard to CRZ, just have a look at page 8 of the additional affidavit. Lord, Your Lordship, just one more page and I'll make my goodbye submission.
43, please come to page 43 of the paper book, the impugned judgment.
43 is the impugned order, Lord, part of the impugned order.
Impugned judgment, paragraph 34.
No, so this I am agreeing to this. So there is one issue, Lord. I'm ready to restore more than what is the part of the CRZ. I'm ready to do that, which is 96 by 67 meter. It's only 43 meter. The controversy is they are asking me to do much beyond my property also and much beyond, Lord. I'll be to that extent, Lord. I'm bound by that. But what I'm showing is something more different, just a legal, totally legal.
You can donate some part of the land.
No, that is not my land at all. It is not my land at all. Just see page 8 of my affidavit, Lord. Additional, just last page and I'll be done, Lord. Just see page 8 of my additional affidavit. This, Your Lordship will see, is the CRZ of 1991 and the 22, Lord, mangrove noticed in this. The petitioner, Lord, she has taken advantage of this CRZ notification. She is also she's just across the river on the right hand side. She is also, Lord, done unauthorized construction, which is not, which I can't use for my benefit, but she has got the advantage of this. Just see the CRZ line is mentioned in that green line.
Get a petition filed against him also.
Pardon, Lord?
If the other your neighbor has taken any
I'm not relying upon that. I'm only saying that she has rightly got the benefit of this CRZ notification, which is being denied to me. That's all that I'm saying. I'm not saying, Lord, that she has got anything wrongly. So just see the CRZ line, 91 was this, and what Your Lordship see, the mangrove, which is in the cross, came in 2022. The blue cross came in 2022. Whatever is done is prior to Lord 22. This blue cross was not there. So the only area which was under the control of the authorities was, Lord, the 43 meter, which is the CRZ line Your Lordship will see in green going across my property. At page 8 of the additional affidavit.
So we can show the undisputed survey.
The survey plan is at page 7. If Your Lordships ask the GCMA authorities, because this is something which is undisputed, they can probably respond to this, because notices have not gone in this matter, so probably they are not appearing. But this line is the 1991 line, where, Lord, the only area which I need to protect was this, up to 43 meter. And the mangrove came only admittedly in 22. Mangrove was not there.
You are not required to, it's not that you have to approve everything. It's only a part of it, a very small part of it.
Lord, small part of it is going to an extent which, Lord, I cannot do, because it is going into somebody else's property. I am only requesting, Lord, that if in law I can show that this is not part of the CRZ at all, which I am being asked to restore, then would this argument is not accepted. This argument is not made before the High Court, not accepted. This also can be remanded if Your Lordship so consider, Lord, back to the only on the jurisdiction part.
In light of the final observation made by Justice Dulia in his judgment, unfortunately,
Lord, that with great respect, Lord, that is against an interim order. And your lordship will not bind me. I mean, this is something well settled. Your lordship has always held that when
Somebody should have pointed out. Now, any view if taken, that will amount to reviewing that judgment.
not really, not because it's only against an interim order. Your lordships are right. There are findings which are almost final in that interim order also. But there are contradictory findings in the very same order which says the High Court will look into all this.
Final observation and consciously, not that sometimes we unconsciously made some observations and those might be.
My respectful submission would be that the learned judge has in the initial part said it is final, but in the later part, Lord, at 327 says that this will all be considered by the High Court. I am only beseeching your lordship that judgment can't be held final against me. That's all that I am holding, Lord, because that's only against an interim order. And today we are against the final order.
What was pending before the High Court was an issue regarding assessment of the damages, etc.
No, not an assessment of damages. The very issue of what is the so let me indicate. There are two NGT orders. The first NGT order is against me. The second NGT order is in my favor. So the High Court had two NGT orders before it, one in my favor, one against me. So High Court was trying to resolve that issue. In the resolution, there was an interim order passed by the High Court. That interim order traveled up to here. This court ultimately sent it back to the High Court for decision. When the matter was sent back to the decision, the High Court says I am bound by whatever.
18.1 minutes. We have a little conflict with 18 minutes. I am one of the landowners who will be affected minutes. I just have two submissions. One will be minutes. Perhaps
I'm the one who gets affected first.
So minutes, kindly take first minutes, page 56, which is the direction of the Honorable High Court. Minutes. The Honorable High Court has implemented me, minutes, allowed me to intervene. After recording, I will be affected. By an interim order, I placed that. In this very matter, your lordship may take this very petition.
On the last occasion, your lordships will remember that I had suggested Mr. Singh and Dr. Singhvi are the main contestants.
But then you said 45 minutes to Mr. Singh and not
suggested
15.
your lordship will remember you had accepted the suggestion that
but your lordship has
Mr. Singh and Dr.
us.
Singhvi are the main contesting parties. The
But
rest of us need not be heard.
But Milits, that
These
was then.
people are on different survey numbers saying that if you restore, we will be affected if the water flows into our land.
They were set up after they
Set up now for the first time.
had lost.
Take
They
the
were
same
set up
paper
after
book.
that.
Just argue any additional argument.
Yes, Milits. Take the same paper book, Milits. We marked it in that. Take the same paper book, page 56. Page 56, Milits, is the direction. And your lordship will see, Milits, in the wake of the aforesaid petition is made absolute in terms of prayer clause BB and BBB. Now, please see that prayer at 210.
Yes.
At page 210, Milits, is the prayer, Milits, which is referred to.
Yes.
For a direction, may I place it, Milits? For a direction to respondent to comply with the directions contained in the order dated so-and-so in OA so-and-so, and to remove the mud filling and reclamation done along the northern, western, and eastern boundary of the lagoon in survey 318/2. Now, I pause, Milits. I am on the south. So, number one, Milits, Mr. Singh's client should not come south. It should be north, west, and east, and it should be limited to survey 318/2 because I'm right below it, Milits, in a different survey. So I had intervened saying that if he now demolishes this in the southern side, so this direction should be fully complied. I have no problem with triple B. This is one point.
So there is no damage, there is no, it's a kind of adverse impact caused to anyone without taking a note of the exact area where this removal or reclamation.
Now, Milits,
all set up.
Milits,
Lost.
now I have my Milits apartment on the south. So I just want it should be on the north, west, and east in survey. I have no difficulty, Milits. Now, insofar as the dimension is. Yes.
Your claim will be against Mr. Singh's client for environmental damages.
No, Milits, I am, if he demolishes my Milits.
Restoration is final today.
Milits, I am saying something.
For restoration, if there is loss of property of a bona fide owner, purchaser, developer, it would be environmental damages paid by the person who has caused that reversal of the lagoon to your client.
I'm saying something else.
Nothing
I'm saying, Milits, I want this direction to be strictly followed, number one. Number two, Milits, Number two, Millets, insofar as the measurement I spelled from your lordship, kindly take page 105, Millets. Page 105. This, Millets, is the very basis of all the orders of the NGT and the subsequent orders, Millets, passed by this Honorable Court. 105, Millets, is also referred to by the Honorable High Court in the impugned order. This is by the expert member of the Goa Coastal Millets Regulatory Authority. Your lordship will notice, Millets, right at the top, this is concerning survey 318/2 at page 105. My lord may also kindly have a look, Millets. 105. Right at the top, this is the survey number. Now, please see para 2, Millets. According to the DSLR plan, the area of the combined plot so-and-so, within the area, the lagoon occupies an area of 95/65. Lagoon had an exit point at the northeast so-and-so. Two structures are shown so-and-so. Google Earth images can be used for comparison. Google Earth image of 2003 shows a large lagoon pond measuring 125/80. These dimensions more or less match the DSLR plan. In comparison, the GE's plan image of 2015 shows the present lagoon is 90/70. So let's one they say 125/80 matches with 95/65, and then the page over, para 7.
Yes, yes. Yes,
If the DSLR plan, GE images, and the present disposition of plot so-and-so is concerned, there appears to be a mismatch, particularly about the size of the lagoon. If the complainants insist, the entire plot will have to be resurveyed, mapped to conform to the changes that have taken place over time. Now, Millet, this very order, this very survey, Millet, at page 116 is the order of the Coastal Authority, which is finally accepted, Millets, by the NGT, and which forms the basis of this Honorable Court's order, which itself had said there is a dichotomy and you need to resurvey. Now, the moment you are making 125 and you go south, he covers my land, Millets, where I have my houses.
You get the environment.
Now, please see, Millets, page 28, this on the Honorable High Court at page 28, Millets, notices para 3 and 7, doesn't notice para 2 of this order, which para 2 categorically notices the correct dimensions, Millets. The dimensions at that point are correctly, but paras 28 and paras 3 and 7 are noticed. And then in page 55, Millets, in the directions.
At the spot, dimensions are mentioned when a measurement takes place at the spot, you people can join.
Millets,
Sorry.
Millets, would you only this, Millets, they should adhere to this BB and BBB, Millets. That is what has been granted. They shouldn't go southwards, Millets.
I'm the person who's directly affected, Lord. I'm the person who's plot 310, which is next to 318, Lord. I'll be
Thank you
affected.
very much. Thank you. Specially petitions are accordingly.
Lord, Lordship may just hear us, Lord, because we were never noticed, we were never given any opportunity,
Yes, it's
Lord.
not necessary to everyone to give a notice. You know. It's not notice the nature give warning.
These are Delhi Golf Links residents who bought villas there in 2022, Malot. And they're coming now to see.
This kind of argument, the point of law is being made.
Delhi Golf Links.
My friend may be living in a better place than that, but why should we unnecessarily think that?
Builders.
All right.
Backfilling a lagoon.
Thank you very much.
No, there is one aspect to Lordship may consider. I'm sorry, Lord, the Lordship had granted me at least 5-7 minutes on the last occasion, Lord. Therefore, Lord, in this case, Lord, I'm the owner of plot 310, public 1, Lord, which is south of plot 318. Now, Lordship has seen 318 is the plot where the lagoon lay, and the distance and the length and breadth has been fixed. Now, Lord, if Lordship would come to page 75 of my SLP, Lord, kindly come to that, where the people who had gone to restore the lagoon, they have clearly said that this cannot be done without encroaching on plot 310. Now, 310 also gets affected, and at no point of time.
You see, these all encroachments, the reclamation, these are whatever exercise required to be undertaken. That.
But kindly look at it this way, Lord. Supposing, Lord, people have been noticed by the Goa Coastal Authority, Lord, as was done in the other case. But we could have gone to the Goa Coastal Authority pointing out, perhaps look into it and please look into it.
When measurements are mentioned, those when the actual at the site, when the exercise.
No, but the court did not give us an opportunity. Not the High Court did not hear us. In fact, in this very case, Lordship, the impugned judgment, we approached the High Court. Paragraph 12, Lordship, just have a notice. The paragraph 12 clearly says, Lord, that this is impossible to comply without encroaching on us. So kindly hear us also. But the High Court has not recorded any finding, nor has gone into that aspect.
Thank you.
So, Lord, we didn't have any opportunity before any authority.
Sacrifice and donate for the cause of nature. That's all.
My lord,
Wait for
item 15, your lordship said Mr. Tankha is here, my lord, if your lordship. Item 15, that election petition matter, my lord, which your lordship said Mr. Tankha, madam, he is here, my lord. But there is a stay which is, but if your lordship see his application 711, page 292, they admit there are corrupt practice, but then there is a defect in the format of the affidavit. And they also admit, Lord, he has not given the details. They say we did not know. Lord, this is a matter of trial. How can it be in 711 decided? That's what High Court has said, my lord. In 711, we cannot go into these questions of fact at this stage.
My lord, with your lordship's leave, may I mention item 36?
Would you-
That is for final disposal. If your lordship may keep it whichever dates that habeas corpus.
We'll give a date wherever the matter we can't, we are both are in a parted matter. So we
Yes,
hear that
that's
matter
what,
first.
my lord. That's why if any short date, since it's a habeas corpus and it's pending 2 years.
Would your lordship have 15 then, my lord, on Thursday, my lord? My lord.
Lord, item number 24.
Can we have next Tuesday?
Next Tuesday.
Lord,
Because-
a short direction we seek in Lord, item number
27.5.
All matters are extraordinary direction, but can be.
My lord, can we possibly have Tuesday next?
Just over, my lord, because Mr. Tankha.
No ordinary matter lands up here, all are extraordinary.
Item number 19. My lord, can we ask Tuesday next in 36?
Item number 24, your lordship has fixed the high power committee for bar council election, my lords. In that direction, only for the state of Rajasthan, my lords, it has not been mentioned.
What happened to that developers matter, Mr. Rajiv?
Lord, in that, my lord, I am seeking one direction. That's an important direction. My lord, I am for the developer. I had, my lord, sold some property prior to my attachment by ED. I have received about 41 crore. Lord, I am seeking appropriate direction that I can give money to the town and country planning department.
The moment you take cognizance, all the developers from where the money comes and how they suddenly become.
Because there is a scheme in Haryana that I can pay EDC, IDC without penalty. So that, Lord, at least those projects can be revived. It is in the interest, Lord, I'm not taking the money away. Just permission to pay money.
We are not taking up matters like this.
My lord, may I please permitted to mention item number 22.
Matter regarding this bar council elections.
Bar council.
We are in not that matter. There is a letter. Who is for the state of Punjab? Anyone? Say, this letter has been received from Justice Ranjit Singh, a former judge of Punjab and Haryana High Court, who was appointed as chairperson of the high-powered election committee in bracket phase Roman 3 capital C.
Bar council.
By the order dated 18th November 2025. Don't say order dated. So by the subsequent order dated 18th November 2025, Justice Jayashree Thakur was further appointed as the returning officer for conducting the elections of the Punjab and Haryana Bar Council. For the conducting the election of Bar Council of states of Punjab and Haryana. Both the former judges have sent letters informing inter alia that the Chief Electoral Officer of Punjab initially conveyed his consent on 20th November 2025 to assist the high-powered election committee for conducting the elections in Punjab as well as in Chandigarh. However, by the subsequent communication dated 8th December 25, the Chief Electoral Officer of Punjab has conveyed inability to conduct Bar Council elections and has further requested to assign the responsibility to some other agency, stroke department.
Yeah, I'm just.
This is claimed to be, this communication is claimed to be based upon an order dated 11th February 1993 of the Election Commission of India. Next paragraph.
We said everything.
Everything.
The high-powered election committee thus seeks directions to the state of Punjab and its chief electoral officer to render necessary assistance in the conducting of state bar council elections. Next paragraph. We do not appreciate the manner in which the chief electoral officer Punjab has sent the communication dated 8 December 2025, whom after digging out some old order of 1993 as an excuse for not rendering assistance to conduct the election of the bar council. We direct one-I the chief secretary, state of Punjab, two-I the chief electoral officer, government of state of Punjab, three-I director general of police, Punjab, along with mutandis directions to the chief secretary, stroke director general of police, stroke chief electoral officer of the state of Haryana, as well as Union Territory Chandigarh, in bracket if any, to render full assistance and provide every logistic support to the high-powered election committee constituted by this court for conducting the elections of the bar councils for the states of Punjab and Haryana.
Right.
A compliance affidavit shall also be filed with them.
May I mention item 20?
Lord, may I re-mention item 36? Can it be on the next
20.
Tuesday?
Thank you very much.
Under compulsion,
My lord.
Kind permission.
may I mention, my lord, the election of Bar Council of West Bengal matter, my lord. I have filed one IA, my lord. The situation is like this. If it is not taken up at an early date, the entire thing will become infructuous. My lord, even my lord's directions was not adhered to. That apart, my lord, 22,000 advocates are not incorporated in the electoral list. Even till today, my lord, half an hour ago, news is the provisional list has not reached, my lord, in the district of.
What are you arguing? Well, is it the way of you just we sit the court and you start arguing a matter?
In the morning, I was waiting here since on 7th, my lord was.
No, which item are you talking first of all, please?
Yes, my lord.
Which item are you?
Item number 24 in the erstwhile bench, my lord. Under compulsion, I am mentioning, my lord.
What is there in that bar council matter? As if the lawyers litigation is the only litigation in this country.
No, it's not that, my lord. Your lordship, since your lordship directed, it has to be, my lord, adhered to strictly. And my lord, it has to be done, my lord, in terms of the bar council's rules. If 22,000 advocates are not incorporated in the electoral list, my lord, the election will become a farce.
Let it be. We are not concerned about that.
With my lord's kind permission, lord's only date for
Your issues have also been resolved
only
now.
for date, my lord, item 21 only for date. And 21 was in the earlier list. Since it could not be taken up, this is Bar Council, Lords Punjab and Haryana, that same order to be made applicable. It was listed on 8th of January last. May give us some date, Lords, 15th or 16th, so that we can put it before my lord. My lords, you should notice in that application, the council for the Bar Council of Punjab and Haryana was appearing that day.
AIB to 19, not included. They have not.
8th of December order to be made applicable.
Provisional list, they have stated that. हाँ? चलो और क्या करेगा?
As my lords, tomorrow is holiday, so maybe my lords, grateful.
My lords, I apologize, my lords, to bother with this unlisted mentioning, my lords, but this is a matter which requires consideration of this honorable court, my lords. My lords, the demolition action is scheduled tomorrow, my lords. My lords, on 10th of January, we have filed this petition before this honorable court, my lords, and on 10th itself, we received a notice that demolition action is scheduled for 14, my lords. We pursued
Thank you very much. It can't be.
my lords, one thing, my lords, since decades we are sitting into this property, my lords, we are the owners, my lords, and we are getting evicted under PP Act, my lords. And during the High Court proceedings, my lords, throughout a stay order was in our favor, my lords, to not to be dispossessed from the property, my lords. It's been more than 3 decades, my lords. It's about livelihood of many families, my lords.
Day after, whatever it is, day after, nothing before that.
My lords, demolition action is scheduled for tomorrow.
Let it be. Then if it is there, if it is illegal, we know how to restore it back. Thank you very much.
My lords, then day after tomorrow, my lords, may have this matter.
Yes, Mr. Dwivedi.
Before my lord,
Operating
Mr.
minutes.
Dwivedi starts, my lord, this side, my lord, the SIR, UP SIR matter, we are about 100 displaced person from one place to other place, and we have been excluded. Our name existed in the earlier SIR. We have filed a writ petition, my lord, and we have representation, etc. But we are not there now. The timelines are proceeding. So the only request is, I have removed all the objections, whatever date your lordship feels appropriate.
Once you have removed the objection, then our standing order is to list the matter.
There is one issue, my lord, there are 100 people and the court fee is around 50,000 something.
Whatever
So that
we are not
they are slum dwellers, my lord.
Once the defects are cured,
That's the objection of fee, my lord, the court fee.
within 2 days.
I have moved an application, my lord. Your lordship may consider this directing, my lord, listing, my lord.
There is no requirement of any direction. That direction is already there. Registry is aware of that direction. You cure the defects, it will be listed within 2 days.
My lord, may I seek your lordship indulgence, item 302, my lord. I've requested my learned friend, my lord, if it's a short matter, your lordship has heard it, kept it for judgment, but 3 times it was listed, it did not reach. It's a legal aid matter. So, my lord, only POSCO came into force after the offense, my lord, and your lordship.
You are talking of serial number 302 or offense of 302?
No, 302. 302, my lord. So, if your lordship, just 5 minutes matter, my lord, if your lordship. 377, your lordship said the punishment is, may extend up till 10 years. May 12, my lord, is the offense. POSCO came into offense in
The offense.
yes, my lord, 2015 is a FIR, 3 years delayed. If we see the testimony, he says it was conducted when he was in 3rd standard, which comes to, my lord, May 2012. That is how, my lord, testimony is. And he says it was only once, and 3 years late is the FIR. And a person who took him has not been examined.
No, let us see in the FIR, where does it say?
Yes, my lord. FIR is on page 21. FIR, my lord, is registered on 14/7/2015 at 8 hours, my lord. So if your lordship will have the testimony on page 23, what he says in court, my lord. Next page. I am studying 9th standard. My date of birth is 31/5/2003. At the time when the incident occurred, I was studying in 3rd standard. We were residing in so-and-so. My school is in so-and-so. I am studying in so-and-so. I know the person shown in photograph. So, my lord, it was also, I don't know how, photo identification. His name is Jagi.
Now, where are you reading?
So he recites, my lord, he says, at the time when it was summer holiday, May month, after finishing 3rd standard. So, my lord, which comes to 2012 May. And POSCO came on 14th of November 2012, my lord. So, since FIR was registered later, but the offense is stated to have been committed in May 2012. And, my lord, he said this happened once only. So, this is a sodomy. So, your lordship then said that your lordship will convert it into 377, which is, my lord, having no maximum punishment.
Who is for this stay? What do you say about only this part of it?
Lordship, so far as this is concerned, section 377 would apply. Section 377 would apply, Your Lordship.
That, mind, your lordship indicated last time also and said that and 377, my lord, there is no maximum punishment. It is up till 10 years, may extend up till 10 years.
How long are you in custody?
My lord, as on, actually, it is 2015 matter, but the custody certificate starts from the date of conviction. His trial period is not reflected in this.
That means he was on bail during.
Maybe but some period, some days also is not reflected, my lord.
How long are you in custody?
That would amounts to, my lord, about 4 years. This 3 years is of 2024. So more than 3 years. More than 4 years, sorry. And trial period, my lord, of more than 20 years.
So 2015 was registered on 14th July 2015 at police station Vadapani. Police station Vadapani. Vadapalani. Under section 3, read with section 4 of the POCSO Act. It was really alleged that committed anal and oral sexual intercourse with the victim X. Who was 12 years old at the time of occurrence. Below 12. 12 years at the time of occurrence. Upon investigation, charge sheet was filed. The appellant's co-accused Bhuvanesh was separately tried by Juvenile Justice Board as he was 14 years old at the time of the alleged occurrence. The appellant, on the other hand, faced trial in SC number 277/2018 of the charges framed under section 12 and 6 of the POCSO. Special court acquitted the appellant under section 12 of the Act, but he was found guilty of committing offence under section 6 thereof and was sentenced to undergo RI for 10 years besides fine of rupees 10,000. The appellant was further directed to pay rupees 5 lakh as compensation to the victim. The aggrieved appellant approached the High Court and while the impugned judgment dated 1st November 2024, the Madras High Court, the High Court of Judicature at Madras has dismissed his appeal. Next paragraph. The special court as well as the High Court have inter alia held that 1I, the FIR was not concocted as the offence was registered after a social worker informed the police. The social worker, on the other hand, was informed by the victim. 2I, the offence was committed against the victim before he attained the age of 12 years, as it began after his 3rd standard annual leave. The absence of injuries on the victim were not fatal to the case, as the occurrence had happened almost 2 years prior to the medical examination. 4, the victim's statement in court stood unchallenged. Next paragraph. The courts, however, also held that the appellant was not guilty of showing any obscene videos to the victim. The High Court also turned down the appellant's contention that non-examination of Bhuvanesh had any serious implications, had any serious impact on the prosecution case. It was further found that the victim's birth certificate proved that he was below the age of 12 years at the time of occurrence. Next paragraph. Is it a legal aid case? Is it a legal aid case?
Yes, my lord.
The instant appeal has been filed after a delay of 679 days, as the appellant appears to be belonging to marginalized section, whom true legal aid has been provided by the Supreme Court Legal Services Committee. As regard to the appellant's contention of false implication, comma, we do not find any substance therein. The victim child and other witnesses have categorically deposed the occurrence and the manner in which a child below 12 years of age was sexually assaulted by the appellant. That being a finding of fact, warrants no interference by this court. Next paragraph. The only meaningful contention that has been raised on behalf of the appellant revolves around applicability of the POCSO Act. It is urged that the victim child was born on 31st May 2003. His age was 8 to 9 at the time. 8 to 9 years old at the time of occurrence, as is established from his birth certificate. That shows that the occurrence took place somewhere in the year 2011-12.
2012.
May 11,
May
12.
2000, May 2012.
In the month of May, he says.
May
11 or 12.
In that shows that the occurrence took place somewhere in May 2011.
12.
Or 12.
12.
May 2012.
Which is prior.
When
the POCSO Act was
14th of November. It came into force on 14th of November 2012.
However, was lodged at the instance of a social worker belatedly on 14th July 2015. The POCSO Act November. The POCSO Act had come into force with effect from November 2012. November 2012.
Yes.
Take me as an exact November 2012. 14 November. 14th November 2012. It is in this backdrop that charges were framed against the appellant for committing offences under the provisions of the POCSO Act. However, seems and could not be could not be denied. Don't say like this. It may thus be seen that in 2011 or till May 2012, when the occurrence admittedly took place, comma, the POCSO Act was not in force. And erroneously has been given. The criminal misconduct attributed to the appellant has been erroneously treated to be an offense committed under the POCSO Act. Right? Absolutely. Next paragraph. This, however, does not absolve the appellant of the consequences that may fall upon him under any other penal law. So, the occurrence, the nature and the manner of occurrence clearly suggests that the appellant was guilty of committing an offense under section 377 of the Indian Penal Code. So, even if no charge was framed under section 377 IPC, we are given that no prejudice can be said to have been caused to the appellant for the reasons that the
Offense under 377 and C.
Lordship, your judgment,
IPC and corresponding provisions under the POCSO Act are cognitive in nature. 2I, the shifting of charge under section 377 IPC does not alter the fact situation, as the same set of facts established by the prosecution beyond any reasonable doubt, overwhelmingly establish the commission of offense under section, overwhelmingly satisfy the ingredients of an offense under section 377 IPC.
And not attract reverse burden.
3I, the sentence under section, for an offense under section 377 IPC being lesser, the shifting of the offense from POCSO to 377 IPC does not cause any prejudice to the appellant. Next paragraph. We therefore, unhesitatingly hold that the appellant was guilty of committing the offense under section 377 IPC and not under section 6 of the POCSO Act as held by the special court or the High Court. Next paragraph. Having held so, we have heard learned counsel for the parties on the quantum of sentence. Also, under section 377 IPC, there is no minimum sentence, though the rigorous imprisonment can be up to 10 years.
Yes.
Up to 10 years. Also,
He has undergone 3 years.
he has already undergone
3 years.
more than 3 years.
4 years.
Sentence.
4 years, my lord, now. 3 years is in 24, July 24. Now, we are in 26.
More than 4 years of actual sentence. He belongs to the poor strata of society. How old was he? Any idea?
40 it is coming at that time.
40,
in
40.
2015.
Taking into consideration the period already spent in custody, it seems to us that the sentence awarded to the appellant can also be reduced from 10 years to the period actually undergone by him. Hence ordered accordingly.
I am so highly obliged, my lord.
For the reasons stated, the appeal is allowed in part. The impugned judgments of the special court and the high court are modified to the extent that instead of section 6 POCSO, the appellant is held guilty of committing an offence on section 377 IPC, and consequently he is awarded sentence to the extent of the period already undergone by him. So, however, there shall be no alteration in the fine or the compensation awarded to the victim. Awarded to the victim. The appellant is accordingly directed to be released forthwith if forthwith he is already under forthwith there is no need, provided that he is not required to remain in custody.
Lordship, some time may be fixed for pay that fine, or some time may be fixed for pay that fine.
That is a default punishment. He is a poor person. If he chooses to undergo in default, my lord, I don't know. I am not aware of. So let it remain like that. So order of
Lordship already reduced the sentence from 10 years to whatever undergone. At least the fine amount should be paid to the victim, Lordship.
It is in default, sir.
There's no
Always
reason
fine.
for reducing this sentence. Since he has to pay 5 lakh rupees compensation, at least that should sustain.
And deposit the fine or does not pay or fails to pay compensation to the victim within a period of 3 months. He is released from jail. Following that event, he shall be liable to undergo additional imprisonment as awarded by the special court.
In default. Yes, ma'am.
Imprisonment in default as awarded by the special court, stroke High Court.
My lord, I am obliged.
Yes, Mr. Diogi.
Lord, on the last occasion, I had drawn my lord's attention to a few articles in the Constitution, Lord, wherein in the event of a member of parliament or a member of legislative assembly, Lord, if he acquires, or if it is alleged that he has acquired a citizenship of another country, then Lord, it is ultimately the Election Commission which examines, and its opinion is binding on the president. Lordship may just note there, my lords, that section 146 of the Representation of People Act 1951, which deals with elections, from 146 to 146C, that, my lord, provides for the mechanism for hearing and deciding, and even powers of civil courts, my lord, are invested in the Election Commission in order to decide that. So in short, my lords, what I was submitting was that in the field of elections, electoral roll and elections, the Election Commission has been entrusted with this task of verifying whether a person is a citizen or not, and only for the purpose of electoral roll and the holding of office here. It's not that Election Commission's decision ipso facto on its own will result in deportation, etc. It's only not that the person will not be included, and there is a possibility that the name would be referred to the government for scrutiny and taking action under the Foreigners Act, etc. So that's the correlation between the enactments under the Citizenship Act and the Foreigners Act and so on. No, we have mentioned some judgments, but I'm not citing that, that's evident. Yes. Actually, the judgments are not required. Not the Constitution itself says that its opinion is binding on the president in so many words. The other aspect, my lord, is I had shown a resolution of the Constituent Assembly of January 9th, 8 January 1949, which is quoted at page 11 of my written submission. Now, in that context, what is I seek indulgence to place before the Lordships the Constituent Assembly debate on that? Because if your Lordship will recollect, Lord, the Citizenship Act has come in 1955. And in 1949, the Constitution of India was not in force. Therefore, Part 2 relating to citizenship was yet not finalized by the Constituent Assembly. And this resolution had been placed. I will not read the whole of it. Initial few pages are objecting to the Vice President that how are you Chair 1358. I will place some paragraphs only. In the middle, the sentence paragraph begins, we have been during the past few days.
Yes, almost in the middle.
Yes. Devoting our attention in the Constituent Assembly to the consideration of articles of the draft constitution relating to the constitution and composition of our future central and provincial legislatures. This, as honorable members are aware, is with a view to enabling the necessary electoral machinery to be set up so that the preparations of the electoral rolls and other connected matters can be taken in hand without delay. As a matter of fact, the Constituent Assembly Secretariat has, under the direction of the President, already taken certain steps for the purpose. In some of the provinces and states, the first stage of the work, namely the preparation of the preliminary rolls, is almost complete. The articles which we have so far adopted lay down the principles and the basis on electoral work has to be carried out. But this is not all. We have also to indicate the time within which to complete the elections, as the electoral rolls will have to be prepared with reference to a set date and prescribe authoritatively the qualifications for voters, etc. The rest will be left notes. Kindly turn over leaf. Then this was the motion which the President wanted to move. The Lordship may just note the item 1, which says that no person shall be included who is not a citizen or unsound mind, two aspects. But kindly come to Mr. Kamath, second paragraph, just below that, just below the motion.
Yes.
Sri H.V. Kamath, second para. Another point is that in subclause A of para 1 of your motion, it is stated that no person shall be included in the electoral roll of the constituency if he is not a citizen. But unfortunately, sir, we have not passed the article on citizenship, and therefore it may raise difficulties for the enumerator or the officer in charge of the rolls as to who is citizen and who is not. So that was the position, that there was no guidance at all. Please turn to the next page, the bottom of the page. Pandit Thakurdas Bhargav is saying some 60 lakhs of refugees are involved and all of them will be obliged to file a declaration and spend at least 2 rupees. So this was the scenario of which your lordships are aware. And next page, then since people were objecting that the vice chairman cannot move, therefore, Lord Pandit Jawaharlal Nehru, he stood up to move the resolution. And your lordship may simply note that it's more or less similar. 1A is there. And then next page, towards the bottom, I heard. Rather, I think I heard an objection that under clause 4, a large number of refugees and others might find it difficult to be enrolled. As a matter of fact, it is.
Where are you reading?
I'm sorry, it's At the bottom, 1362.
1, 2, 3, 4 are there.
Yes, I heard it begins. Last paragraph.
1362.
At the top left side, page number is 1362.
Bottom last paragraph.
And at the bottom last paragraph, I heard.
No, that's it. Next page.
My Lord Justice Bakshi has not? I heard, rather, I think I heard an objection that under clause 4, a large number of refugees and others might find it difficult to be enrolled. As a matter of fact, it is not intended to create any difficulty or any obstruction. But surely, some kind of intention has to be given. Otherwise, you cannot enroll everybody without knowing whether he wants to be here, whether he proposes to stay here or not. It is for provincial governments to take steps to facilitate this process. Suppose a person who enrolls has not even the intention to stay. Therefore, it is proposed that some kind of intention should be declared of permanent residence. You will see that the clause was really meant to be in favor of the refugees because normally speaking, you lay down some qualification of residence, etc. in a particular locality. Now, because many of the refugees who have come here may not be able to fulfill the qualification, therefore that clause was put into facilitation to facilitate their coming in. Then next page, my lord. Shri Shastri, Alguram Rai Shastri. May I request you, sir, to allow me to ask the mover to explain one point. The citizenship clause shall remain held up. How can there be any electoral roll unless we have decided the fact as to who is a citizen of India and who is not? Honorable Pandit Jawaharlal Nehru, these electoral rolls can be prepared and are going to be prepared. Whatever the future decision of the Assembly in regard to the citizenship clause might be, it will only affect the preparation of those rolls slightly. The citizenship clause does not affect the vast number of people in this country. It affects only two types of persons, ultimately, persons who may be called refugees, to Indians who reside outside India, which I say is more important. They are affected, that is, we accept a citizen, anybody who calls himself a citizen India. But there is difficulty in respect of people residing outside India, since the matter is to be decided by the Assembly later. It is not very difficult matter to arrange for them. They will come into the picture after we know the decision of the Assembly. It does not interfere with the work. Only a very small part of work is delayed till you decide that. As soon as you decide that, effect will be given to it. So let us proceed. For the moment, even if a refugee is come, if he is willing to say that I am an Indian, to a mere declaration, that would be sufficient, Mallards, and they should be brought in. But ultimately, we will take a call, and as soon as we call, then we will give effect to it later on. Then, Mallards, kindly have at page 1366. Third paragraph.
1366.
1366, third paragraph. It is true that the question relating to citizenship that had been raised by me has been answered to a certain extent by Pandit Jawaharlal Nehru. But I submit, sir, that even if a few people only are likely to be adversely affected, it is desirable that ample provision be made so that not even a single person entitled to be a voter may be deprived of his voting right. I cannot lay too much emphasis on it, for it is evident that this is the most valued right of a voter and one of which he must be given the opportunity to exercise. It is submission, sir, that there should be some provision as to avoid the least possibility of even a single person otherwise entitled to be a voter losing his right of vote. I am afraid that difficulties arising as a result of the question of citizenship have not been fully removed as yet. Lordship, we then come to the last four lines. I may add that citizenship and delimitation of constituencies are the keystones of any scheme of electoral roll, and as such, an electoral roll cannot be prepared unless electoral rolls, unless they have been properly defined. Then overleaf in the middle of the statement of Pandit Jawaharlal Nehru, The sentence begins, for instance, one of the points. Your Lordship has this paragraph, no? 1367. In the middle of the paragraph, my lords, next 1367. That's a statement of Shri Jawaharlal Nehru in the middle. Sentence begins, for instance, one of the points raised by Mr. Kamath is that only 2 disqualifications are mentioned and not others. If you will see the resolution, it says, the state electoral rolls be prepared on the basis of the provisions of the new constitution, agreed to by this assembly. That is one thing, and that the other is in accordance with the principles. That is, all those mentioned in the constitutions are there. It is in addition to that, something that is further mentioned. These are 2 things. If he is not a citizen of India and if he is of unsound mind. I will confess to the House frankly that saying that if he is not a citizen of India is rather unnecessary. This is very important, Lord. Lordship may kindly be pleased to note this, Lords. That is saying that if he is not a citizen of India is rather unnecessary. I mean to say, it is a fact. The Constitution is based on that. This is what I said, Lord. Our Constitution is citizen-centric. Is based on that. And if it is left out, it makes no difference. It is really to round off. So even if it had not been said, still, Lord, it is only the citizens who can get on the electoral roll. Something is said at the bottom of the paragraph by Shri Nehru, Lord, about unsound mind. We are not concerned, but except that at page 1368, in the context of unsound mind, that every person, objection was that everybody will have to go to court. I do not understand why anybody should go there at all. A few persons of unsound mind may get into the rolls, but many persons of unsound mind who are not declared to be of unsound mind come in and not only vote. What do many other functions too? We cannot simply help it. What we want to guard against is this: a person should not be ruled out on account of some prejudice or wrong decision. There must be some guide to the enumerator. The decision of court surely must be recognized by the man who has to prepare the electoral roll for the rest. It is further law is passed by the assembly, I should think that would be good. But it is quite impossible not to accept the decision of court. It is not necessary, I submit, for you to state to say, subject to any other rule that may be made. If this House passes any other rule, the enumerator will follow them. This is a preliminary electoral roll. You cannot go into too great specifications and details. These rolls will no doubt be checked later. These rolls no doubt will be checked later or in accordance with the rules and laws passed by the assembly or by provincial assemblies, as the case may be. But in the first instance, too many details cannot be gone into. You must remember that the man who is going to prepare them is an ordinary type of enumerator, and he will have to go by his own lights, which may not be very great. Afterwards, they would be checked by the other people concerned. So that first of all, the disqualifications mentioned in the Constitution as being passed will of course be given effect to. If you like, you may leave out if he is not a citizen of India, because it is redundant. So finally, in the resolution, it was removed. But as I have shown in my written submission, it was introduced and the provision was ultimately passed, Lords.
That time.
Yes.
So I think some of the expressions must also be
understood in the time context. Absolutely, Lords.
And
So,
because of Mr. Chaudhary is a bit irritated also,
yes,
as it
right.
was mentioned there.
I'm grateful, Milord, for this observation, Milord. This is what I wanted to stress that whether it be the speeches in the assembly or, my lord, even the judgments, my lord, sometimes, my lord, when lordship writes judgment, my lord, some sentences, stray sentences come in. Sometimes based on arguments, sometimes because the judge thinks it appropriate that it should be there. So all judgments your lordships have said, my lord, should not be understood as like a mathematical formula of Aryabhatta. It's not a thesis of science, my lord. It has to be, nothing is chronos free. In the specific circumstances, the particular time, because in fact, sometimes the lordships overrule the judgments delivered 1950s and 60s, not because they were wrong at that juncture. At that time, India had to be, its integrity had to be safeguarded, it had to be strengthened, the centralized government had to be strengthened. So everything is kept in the back of the mind, and therefore with that, a judgment is delivered. But with change of time, with discovery of basic structure, etc., now things are looked afresh, and therefore a different view is taken. That's most often it happens when a view is changed. Everything has to be looked into. But what I'm trying to, another aspect is that even though it was deleted in January, but in June, that is at page 15 of my written submission on 16th June, specific provision was introduced and that was passed by the Assembly, which said that adult suffrage and citizenship was brought in. So within 5 months, they said they cured that objection that there is no provision of citizenship as yet. Now, having said this, the other aspect which is now put against me was Section 9(2) of the Citizenship Act. I have shown to your lordship Section 9(2), which says that if somebody acquires citizenship of another country, that's one situation alone where central government is empowered. Now, please have page 22 of my written submission. कौन सा judgment था जो? Item 5R judgments along with this. There are two sets of cases, judgments. One, my lord, where somebody has acquired citizenship and therefore your lordship says, my lord, that Section 9(2), we will not look into it, go to the central government.
463. 460.
So one moment. 5R, na? Kindly first have, my lords. This state of Andhra Pradesh versus Abdul Khadir, that is at page 476. Paragraph 8 and 9. Please have paragraph 5 first. The learned judicial magistrate found that by obtaining the passport from the Pakistani authorities, he has disowned Indian nationality and he has ceased to be an Indian national. He also held that Section 9 of the Foreigners Act did not apply to the case, but Section 8 of the Act did. And that under that section, a decision made by the government that a person is a foreigner is final and such a decision. So he took a view that you have to go to the government. Now kindly come to 8. Now Section 9(2) of the Citizenship Act 1955 provides that if any question arises as to whether any citizen has acquired the citizenship of another country, it shall be determined by such authority and in such manner as may be prescribed under Rule 30 of the rules framed under that Act. The authority to decide that question is the central government. So the question whether the respondent, an Indian citizen, had acquired Pakistani citizenship cannot be decided by the courts. The learned magistrate had no jurisdiction, therefore, to come to the finding on the strength of the passport that the respondent, an Indian citizen, had acquired Pakistani citizenship, nor was there anything before the learned magistrate to show that the central government had decided that the respondent had renounced Indian citizenship and acquired that of Pakistan. Now leave the rest, Lords, kindly have paragraph 9. The question whether a person is an Indian citizen or a foreigner, as distinct from the question whether a person having once been an Indian citizen has renounced that citizenship and acquired a foreign nationality, is not one which is within the exclusive jurisdiction of the central government to decide. The courts can decide it, and therefore the learned magistrate could have done so. He, however, did not decide that question, that is, find that the respondent had been a Pakistan national all along. On the evidence on the record, such a finding would not have been warranted. For all these reasons, we think that the conviction of the so-and-so was not ill. So I'm emphasizing this. If it is a question of acquiring citizen, then central government. All other questions, there is no bar. Even the courts can examine whether, if somebody files a suit today that please declare that I'm a citizen. Now there is no provision in the Citizenship Act for that purpose. So that will be maintainable. Now, then kindly have 779. Oh, I'm sorry, page 472. Page 472. Paragraph 2. The appellant, this is Akbar Khan versus Union of India. The appellants had filed a suit for a declaration that they were citizens of India and for an injunction restraining the defendants from removing them from India. The defendants were the Union of India, the state of Madhya Pradesh, district magistrate in Madhya Pradesh. The appellants stated in the plaint that they were citizens of India and had not ceased to be citizens. They had said that in the beginning of 1953, they went to Pakistan for a temporary visit without a passport. But when they wanted to return, they were compelled to obtain a Pakistani passport. They stated that they obtained these passports only as a device for securing their return to India and had really been compelled to obtain the passports against their will. That was the factual backdrop. Then kindly have paragraph 5. They quote section 9(2) in paragraph 4, which was being relied upon to get the suit dismissed. It seems to us clear that subsection 2 of section 9 of the Citizenship Act bars the jurisdiction of the civil court to try the question there mentioned, because it says that those questions shall be determined by the prescribed authority, which necessarily implies that it cannot be decided by anyone else. The only question, however, which a civil court is prevented by section 9(2) of Citizenship Act from determining is the question whether a citizen of India has acquired citizenship of another country or when or how he has acquired it. The civil courts are not prevented by this provision for determining other questions concerning nationality of a person. There is no doubt that the suit by the appellants raised the question whether they had lost their Indian citizenship by acquiring the citizenship of Pakistan. The appellants themselves had raised that question by pleading in their plaint that they had not voluntarily acquired the citizenship of Pakistan. To that extent, it has to be held that the appellant's suit was barred. It seems to us, however, that the suit raised other questions also. The appellants claim that the citizenship of India was resisted on the ground that having migrated to Pakistan in 1948, they had acquired Indian citizenship, never acquired Indian citizenship. That might follow from Article 7 of the Constitution. The jurisdiction of civil court to decide that question is not in any way affected by Section 9(2) of the Citizenship Act. Therefore, it seems to us that the entire suit should not have been dismissed. The court should have decided the question whether the appellants had never been Indian citizens. If that question was answered in the affirmative, then no other further question would arise and the suit would have to be dismissed. If it was found that the appellants had been on 26 January Indian citizens, then the only question whether they had renounced that citizenship and acquired foreign citizenship would arise. That court could not decide. So therefore, it's a very limited bar under Section 9(2). Now, similar is the position in Shah Muhammad's case, that is page 466. What?
Please?
It begins not at page 466, Shah Muhammad, State of UP versus Shah Muhammad. Relevant portion is this paragraph 5.
Yes.
At the last 3 lines of paragraph 5. This article thus deals with cases where citizenship of a foreign state had been acquired by an Indian citizen prior to the commencement of the Constitution. Why so and so? However, Article 11, however, makes it clear that Parliament has the power to make any provision with respect to acquisition and termination of citizenship and all other matters. Parliament could thus regulate the right of citizenship by law. As pointed out in the above decision of this court, it would be open to Parliament to effect the rights of citizens, and the provisions of the parliamentary statute cannot be impeached on the ground that they are inconsistent with the provisions in other articles in Part 2 of the Constitution. The Act has been enacted under the provisions of Parliament preserved by Article 11 in express terms. The Parliament had also legislative competence under Entry 17. It could thus make a provision about the forum where the question as to whether a person had acquired a citizen of another country could be determined, and this is what has been done by Rule 30. Then paragraph 6. Kindly come to Placitum G. We are unable to agree. In our judgment, from the amplitude of the language employed in Section 9, which takes in persons in category 2 mentioned above, the intention has been made clear that all cases which come up for determination where an Indian citizen has voluntarily acquired the citizenship of foreign country after the commencement of the Constitution have to be dealt with and decided in accordance with its provisions. In this view of the matter, the entire argument which prevailed before the Allahabad High Court can have no substance. Then kindly come to paragraph 8. In conclusion, it may be mentioned that this court in several cases has consistently held that questions falling within Section 9(2) have to be determined to the extent indicated therein by the central government and not by courts. Such matters are not covered by the provision, have, however, to be determined by the courts. So the moment the subject matter is different, not covered by 9(2), then the courts, and if there is any other authority prescribed, they can examine this. And the last in this series, my lord, is Sarbananda Sonowal's case, paragraph 81. Begins at page 463. And paragraph 18 is at page. Paragraph 81. Yes, at page 463, para 81. Shri K.K. Venugopal has submitted, has this at page 463, para 81, has submitted that section 8 of the IMDT Act is similar to section 9 of Citizenship Act, and therefore the same interpretation should be placed upon section 8. In our opinion, it is not possible to accept this contention. Section 9 of the Citizenship Act applies to a situation where question is whether an Indian citizen has lost his citizenship by acquiring the citizenship of a foreign country. Such a question can be decided only by central government. We are concerned here with identification and deportation of such Bangladeshi nationals who have illegally crossed the international border and have taken up residence in Assam. The question of loss of Indian citizenship on account of acquisition does not at all arise for consideration. So if there is a pure and simple question, whether you are a citizen or not, there's one more judgment. I'm not reading that. Lordship may just note here itself, it's not mentioned. And that is 1964 7 SCR 441. 1964 7 SCR 441. Paragraph. The paragraph 8 above paragraph 9. The sentence begins, it is only where there is proof that a person is to start with a citizen of India and it is alleged that he has lost his citizen by virtue of so-and-so, then section 9(2) is attractive. And then there was a AIR 1965, Calcutta, page 1. It is at page 558. 558. Paragraph 4, no?
4 is for the year or 9 to 46.
Kindly have got the page 559, paragraph 1, section 9(2).
Should be paragraph 2.
So 2 judges bench. Justice Bachawat, as his lordship then was, lordship. Section 9(2) of the Citizenship Act does not preclude the tribunals from recording the finding that the appellant had migrated to Pakistan in 47. Let's have this. And therefore never became a citizen of India. Section 9(2) debars a court from trying the issue whether an Indian citizen has acquired the citizenship of another country. But the section does not bar the court from considering the question whether the person concerned ever became a citizen of India. Then the court, Supreme Court judgment, the appellant having migrated to Pakistan never became a citizen of India on the commencement of the constitution. In civil rule so-and-so, Chaudhry Abdul decided on 29 January, unreported, Justice Banerjee seems to have decided the case on the footing that the opting for service under the government of Pakistan and going out of India gave rise to the question whether the person concerned had renounced. And I am unable to agree to the decision if a person has migrated from the territory of India after the first day of March 47 to the territory now included, he cannot be considered to be a citizen of India having regard to Article 7. The civil courts are in no way precluded. Then Justice Mukherjee, in paragraph 4, under section 16 of the Representation of People Act, a person who is not a citizen of India is disqualified for registration on the electoral roll, and the name of any person who has become so disqualified for registration shall, if his name is already on the electoral roll, be forthwith struck off from the roll. The appellant's name, it appears, had been entered in the electoral roll of the Murarai Assembly constituency, and the electoral registration officer of Rampur Hat served a notice on him under section 22 asking him to show cause. For taking action under section 16, the electoral registration officer had to decide whether the appellant was or was not an Indian citizen. In the instant case, he came to finding the appellant was not such a citizen. Under section 30 of the Representation of People Act, the question whether the appellant was entitled to be registered is one which the civil court has no jurisdiction to entertain or adjudicate upon. The legality of the decision of the ERO and the action taken by him for revision of the roll cannot be questioned. It is clear, therefore, that the order of the ERO or the subsequent order of the Chief Electoral Officer affirming the order of ERO cannot be interfered with except on the ground that they had no jurisdiction or their decision was perverse, in the sense that there were no materials before him on which it is by respectful submission, my lord, under 326, and as also, my lord, the this Representation of People Act 1950 and the RER rules taken all together, the Election Commission, of course, not itself, my lord, but through the officer which is designated under the Representation of People Act, namely the Electoral Registration Officer, is competent to take a view. And as my Lord Justice Bakshi had was pleased to observe, my Lord, during the hearing, that an inquisitorial inquiry about citizenship can happen, my Lord, for specific purposes.
The inquiry into the citizen.
Yes. Now, for example, my Lord, under the MMRD Act also, when a person wants a lease for mining, one of the conditions is that he should be a citizen. Now, if somebody applies, my Lord, that authority will certainly want some examination of are you or are you not, because nowadays, my Lord, even foreign companies are.
Thing is, Mr. Dwivedi, he can inquire. After he records a finding, is it under the scheme of the Citizenship Act required that his finding be referred for a decision, as you say, for appropriate steps and decisions by the central government?
That we have included in the SIR itself. I'll show to your lordships that once it's finding not included.
Until then, can you take away the right to? Till a decision is taken by the central government, stripping him off of the
That would be for the
of the
purposes
color of citizens.
that is for the, that would be for the purpose of examining whether he's entitled to stay in India or should be deported or not. As far as the electoral roll is concerned, he has to be,
According to you, even prior to that, you can strike him off the electoral.
yes, that's my humble submission, my lords. In various acts, there is a requirement of, as I said, not that you should be a citizen. Now, it can't be, my lord, that under the Mines and Mineral Act, my lord, the authority comes to a conclusion that the person is not a Indian citizen. Then he will grant a lease. He has to take a decision there and then should he grant, execute or not execute. Reference may happen. Sometimes the references not maybe go in favor of the person concerned, and then he will be again included. He may be granted the lease. These things will happen, my lord. Ultimately, the whole electoral exercise cannot be, my lord, halted, stopped, or modified on account of the fact that some people have been found. Of course, if it is perverse, etc., my lord, I am not defending on individual facts. If somebody questions and it is found by the courts, my lord, that it's perverse exercise, no material, etc., then that particular order will go.
Your argument is that non-citizens are not
Entitled. That's the expression in 326. One of the argument was, my lord, that section 16 changes the position and says it's a disqualification instead of entitlement. But an act of parliament cannot alter 326 first. 327 starts by saying subject to the provisions of these constitutions. So that's a matter, this section 16, 18, 19 have to be understood in the light of 326. They can't detract from that situation. So the material that it has been put in this disqualification, that's simply a saying entitlement, disqualification. I mean, that's the other side of the coin. If a person is disqualified, he can't be included. If he is not entitled, not included. So there's no conflict. It's just a negative way which the parliament has chosen to put it. It would have been appropriate to put that citizenship in the entitlement section, which is probably 17 rules instead of 16. Hmm. 19, I'm sorry. It should have been in 19. That talks of entitlement. But anyway, the parliament's law has to be understood in the context of it can't alter, it can't change.
Article 320.
Yes. So having submitted this, Lord, that we are entitled to look into the citizenship and we don't have to wait, Lord, for a decision, ultimate decision, which may go one way or the other. There is enough safeguard because the person can file appeal. If appeal, Lord, then he can file. In so many other cases, Lord, where a person is excluded on some ground, ultimately his remedy is to go to appeal and then to courts, Lord, and when it is set aside, he is put back, Lord, and that's a specific provision. If it ultimately it is set aside, then without delay he'll be restored. So these are, Lord, normal processes of law. The consequence of taking the other view would be that even though the electoral registration officer has found that he is not a citizen, yet he will still include him in the electoral roll and he will vote. So once a shadow is cast on his citizenship, as long as it is not perverse and arbitrary, he needs to stand out. And it's not something which is happening forever, time. few people, as even Pandit Nehruji said, my lord, that some people may still suffer, my lord. Nothing is perfect. Whatever may be done, whatever processes may be adopted, howsoever, my lord, something or the other will remain. We have to chase the utopia of perfection as near to it as possible. Now, having said this, my lord, the one question still remains. 326 does not tell us, my lord, how to decide citizenship. The criteria of deciding whether you are a citizen or not. And we are no more, my lord, in the stage of 1950s, because Constitution doesn't tell us, my lord, that what is to happen, how you are going to determine citizenship post the enforcement of the Constitution. If your lordship may have that provision again and see. Constitution. That is the Constitution. It only talks there are two aspects which I need to clarify here. Section 5, Article 5, at the commencement of this Constitution, every person who has his domicile in the territory of India and who was born in the territory of India, B, either of whose parents were born in territory of India, C, who has been ordinarily resident in the territory of India for not less than 5 years, immediately preceding such commencement shall be citizen of India. But this applies at the commencement of the Constitution. Now, what is to happen after? Because this is a continuous process of people coming into being and passing out of being. Then 6 talks about those who have migrated to Pakistan, etc. 7 also.
Expressions used in Article 5, 6, and 7
Yes.
are of transitional nature.
That-
So the country was still under division. The dates were extended at that time, and at the time of formation, the people were still, some of them were yet to take a final call
Yes.
of where they will settle down. And after that exercise is complete, that acquiring citizenship in terms of the constitutional provision itself, then comes probably 10, where the
Yes. 10 says continuance. And this is very important because this is simple, Dalit Senior Council relied upon section 10 to show that once you are on the roll, I'll answer that Lal Babu later on. But here he relied on 10 also. Every person who is or deemed to be a citizen of India under any of the foregoing provisions of this part. So it has nothing to do, with subsequent. It is only concerned with those who at the advent of the Constitution, once you are a citizen, then you continue as a citizen, unless, of course, for reasons of other law operations. So therefore, Lord, this section 5 to 10 doesn't help us in deciding. It furnishes no criteria for deciding how, Lord, but it does tell us two things, that domicile and birth in India are important. Please mark this, Lord. It does say that at the commencement of Constitution, who has his domicile in the territory of India, and 2, that he was born in territory of India, or either of whose parents was born in territory. And then coupled with that, ordinarily resident for 5 years. So domicile, residence, and birth in India. The most important factor is born in India. Now pursuant to
Actually, five extends the constitutional right of citizenship and does not freeze it to the commencement because of clause B. Parents born. So children of those persons also get the citizenship from Article 5.
But it starts by saying at the commencement.
Correct, at the commencement and is born in India and whose parents have been born in the territory of India also.
So then they will be they will be deemed to be citizen.
By
Because once the constitution comes into force, we must know who are we the people.
Yes.
So therefore, this says, at the commencement, this is the criteria. I'm also relying upon, I have no issues, we can look at it, my lord. That's one way of looking at it. But therefore, Article 5 also tells us 3 factors are mentioned there: domicile, residence, and born in India, or parents born in India. So having been born in India, parents being born in India, these are valid criteria which the Constitution tells us. But Section 3 of the Citizenship Act, which has been framed,
funneling it down.
that
Later on, it funnels it down.
that extends the very same criteria for the future. And subsequently, there are vital modifications, which are very significant and need to be borne in mind. Citizenship Act. Please. Citizenship Act. Please have a look at section. Though I had referred to Article 5 only for the purposes of culling out the criteria, but my lords may note.
We have understood your submission that 5 actually is at the commencement, and therefore the constitutional presumption also vests with the commencement only.
Yes. And furthermore, my lords, clause A and B both use the expression was. Who was born.
You are right.
Either of whose parents was born.
So
it shows in the past.
Prior to commencement.
That's right. But gradually we have. So therefore, this, however, in the first election, this was not there, 1955 Act. first election 1952. So that happened, my lords, on a general perception of what is a citizen, my lords, because 326 had come. And these acts had also come in 1950, Representation of People Act 1950 and 51, actually by the Constituent Assembly itself. So the first election, but that was a different time. It's the beginning. We are forming a nation state. But as times have gone, your lordship will look at section 3 of the Citizenship Act. The definition.
1952 was a very unique situation.
Yes.
It was a very peculiar situation. All those who decided to stay here, they were Indian citizens because each one of them was an Indian citizen before 1947.
That's right.
So obviously those who stayed back here or those who temporarily went but eventually decided to come and settle, they continue to be Indian citizens. So 1952 has a very simple benchmark that those who have stayed back here are Indian citizens.
Are you intending, as Pandit Nehru says, we must have an intention.
We have funneled our citizenship.
Yes.
First it was just birth. Then it is birth plus one parent. Now it is birth plus two parents.
So gradually
Both
we have
parents.
become more stringent.
That's what we said, funneled the citizenship.
Yes. Because the objective was that our
पहले birth होने
I did not read.
After 1950. Originating from the Constitution.
In fact, delimitation of constituencies also had not happened in the first election. It's the same old constituency we existed. So there was no option.
Government of India 35.
So when we start something, my lord, we have to take what exists. And then gradually, my lord. But even at that time in the assembly, there was considerable debate that we should not make our citizenship, my lord, very cheap. One of the members said, my lord, supposing, my lord, somebody is flying on the plane and flies over the territory of India and the child is born, will he get the citizen or not? So they wanted some more conditions to be there about residence, etc. That's how Pandit Nehru's lordship notice said 18 months. Then they finally ended with 5 years.
Right.
So the trend was to make it more stringent. And section 3 has been amended, I think, once in 86 and once in 2004. Now, this is very important because there are 3 clauses now of a different kind, different from Article 5. Except as provided in subsection 2, on or after 26 January 1950, but before first day of July 1987. That is because in 86, there was an amendment. B, on or after first day of July 87, but before the commencement of Citizenship Act 2003, and either of whose parents is a citizenship at the time of his birth. So he should be born, either of their parents should be born. Then C, on or after the commencement of Citizenship Amendment Act 2003, where both of his parents are citizens of India, or one of whose parent is citizen and the other is not an illegal migrant. So gradually in 2003, we had become, because it has been noticed, and there was a lot of agitation in Assam and elsewhere about illegal migrants, cases had come to this court. So things were made more stringent with change of circumstances. Now this illegal immigrant has been noticed, and it's important also for the reason that this 2003 Act also created a new kind of citizenship, that is overseas citizenship of India. For example, somebody gets married with a woman who's of another country, then she can apply for, she retains her citizenship, applies for after a certain stay in India for 5 years or so, then you apply and get an OCI. Then you are allowed to stay in India and live in India or enjoy so many other benefits, but you can't get on the electoral roll. That's why it says illegal migrant. If you have a long-term visa, etc., you can stay on. You are permitted to stay on. If you are a recognized refugee, you may not still be deported, but you can't get on the electoral roll. So the definitions for us have changed over the course, and today they are more stringent. And I will demonstrate, Lord, that our SIR, when I deal with, show your lordship, the SIR, then your lordship will find, Lord, that we have included provisions which are very close to this. And we have also included appropriate presumptions. And that I'll explain, Lord, when I deal with the SIR. May I continue the next statement?
All right, Thursday. Not that we are curtailing any time. Approximately, suppose you continue non-stop. Approximate how many hours you need?
Because in a week thereafter, because I get, your lordship will be having other matters also. So even if I'm getting 1 hour, 1.5 hours every day.
That's why we are trying to keep the other matters on Monday, because there is no other way out. So that Tuesday, Wednesday, Thursday,
In the next week, we'll.
hopefully it will be over.
Yes. I have now to deal with the other constitutional question also, Mullah, that is, what is the relationship between the parliamentary law and Article 324 and all?
We will try on Thursday. Let me see that how many matters and how can we deal with. We will try on Thursday, even before lunch, to start. If it is possible, after finishing some fresh matters, if we can take up.
Lordship may have it after lunch, because given my state of, Lord, I'm not on before lunch. Lordship may have it post lunch only.
He wants after.
Next week.
Chhattisgarh Coast and Enforcement Directorate, Mahada.
I have to fight both the illness and the drugs.